So good afternoon. We can do better than that. Good afternoon. It's my distinct pleasure to welcome you all to this commemoration of the 150th anniversary of the ratification of the 14th Amendment. My name is James Cadogan. I am the director of the Thurgood Marshall Institute at the NAACP Legal Defense Fund. For those of you who don't know us, the Thurgood Marshall Institute is a group of lawyers, researchers, archivists, organizers, and academics housed within LDF. Founded in 2015, we've got some pretty incredible talent at TMI, and before you ask, yes, the pun in TMI is indeed intended. We couldn't be more excited to be here at the National Constitution Center and partnering with NCC's fantastic team in bringing you today's programming, which traces the history and legislative dynamism of the 14th Amendment. Now, the precepts of the 14th Amendment, equal protection, due process, citizenship, we know that these are ideas that are critical to our country's evolution as a participatory democracy, but it seems they've somehow gotten lost in today's debates. And that's why marking this anniversary is so very important. By bringing together scholars and thinkers who can trace the impact of the 14th Amendment from its ratification 150 years ago through to the present day, we want to begin to bring those principles back into our national dialogue. Now, I have the easy job today, which is to play MC and make sure the trains are running on time and help put out any inevitable logistical fires that may arise. So a couple of housekeeping notes first of all. While we are going to look back across the centuries today, we are actually in the 21st century, so we will be on social media. I'm going to give you our handles, so please follow them and tweet liberally. For NCC, it's at Constitution Center. That's at Constitution CTR. For LDF, it's at NAACP_LDF, at NAACP_LDF. And for TMI, it's at TMI_LDF. That's at TMI_LDF. And we will also be live streaming all of the conversations today online. Housekeeping aside, the real work today is going to be done by the distinguished group of scholars and panelists who will be joining us throughout this afternoon. To that end, I will now hand things off to the official hosts of our event, who will provide some framing remarks as we begin discussions. So please give a warm welcome first to the President and CEO of the National Constitution Center, Jeffrey Rosen, who will then introduce Sherrilyn Ifill.
Good afternoon, everyone. Welcome to the National Constitution Center. I am Jeffrey Rosen, the president of this wonderful institution, which those of you who have been here before know is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. Beautiful. Thank you so much for that rousing declaration. And out of all of the crucial provisions of the U.S. Constitution, it is hard to think of one more meaningful to celebrate than the 150th anniversary of the 14th Amendment. The 14th Amendment was ratified on July 7th, 1868, and it ensured that the equality promised in Jefferson's Declaration, betrayed by the original Constitution, resurrected by Lincoln at Gettysburg, was finally enshrined in the Constitution, guaranteeing to all citizens privileges or immunities and basic rights, and to all persons the equal protection of the law. Our commemoration of the 150th anniversary of the 14th Amendment today is part of a series of panels, symposia, podcasts, and debates. We'll reconvene on July 7th here at the Center for another constitutional conversation, and all of these great activities will culminate early next year in the opening of the first gallery in America devoted to the constitutional legacy of the Civil War and Reconstruction. We're calling it A New Birth of Freedom, the Constitutional Battle for Equality. And it will contain rare artifacts, including the flag that flew over Independence Hall in 1861 when Abraham Lincoln said, "I would rather be assassinated on this spot than forsake the principles of the Declaration," with rare copies of the amendments to educate all Americans about these crucial guarantees. You are in for an extraordinary treat. We've assembled the greatest scholars, legal historians, and historians in America to discuss the 14th Amendment. And all of this phenomenal activity is possible only because of the vision of our great partner, my friend, Constitution Center board member, and great champion of the 14th Amendment, Sherrilyn Ifill. Sherrilyn is the 7th president and Director-Counsel of the NAACP Legal Defense and Education Fund. She emailed me a few months ago and said, hey, why don't we mark together the 150th anniversary of the 14th Amendment? And I said, I'm so honored. I can't think of any group that we would rather do this with. And together, our phenomenal teams have put together this extraordinary group of scholars for your edification. Sherrilyn is a distinguished law professor, litigator. She's won landmark Supreme Court cases, and she's a critically acclaimed author, including of the book On the Courthouse Lawn, Confronting the Legacy of Lynching in the 21st Century. I'm so proud that she is a collaborator of the Constitution Center. Please join me in welcoming Sherrilyn Ifill.
Good afternoon, everyone. I'm thrilled to be here. I love the National Constitution Center, as Jeff knows, and I hope that you'll have an opportunity to spend time in the building today. I really do think it is a national treasure. This conference was really important to me, and I'm so thrilled that Jeff so readily agreed to have the Legal Defense Fund and the National Constitution Center co-sponsor this conference. I'm privileged and honored to lead an organization that is the oldest civil rights legal organization in the country, founded by Thurgood Marshall in 1940, and to be the 7th leader of that extraordinary organization. It was my dream as a young girl to be a civil rights lawyer, and that dream came true, but I could never have believed that I would be in this extraordinary position, leading this organization that has been so important to American democracy. I wanted to participate in this gathering today and to make sure that we commemorated the 150th anniversary of the 14th Amendment, because in some ways it astonishes me how little the 14th Amendment is talked about in public life. When people think about themselves as Americans, they very readily talk about their First Amendment rights. You can't tell me not to do that. I have the rights of the First Amendment that cover me. People very readily talk about their Second Amendment rights. And yet, I think the amendment to the Constitution that fundamentally shapes the modern vision of Americanness, the modern vision of citizenship, the principles of equality that we use to describe this country and justice, they are enshrined in the 14th Amendment, the amendment that set right, that hit the reset button on American democracy. Now, even though we're commemorating the 150th anniversary of the 14th Amendment, I want to be clear that this amendment is not static. It has taken not only the litigation, but the struggle, the blood, the sweat, and the tears of millions of Americans to make those words even approach their true meaning. If you are a civil rights lawyer, the 14th Amendment is the center of all that you do. And you recognize that it's the sacrifice of ordinary people who are willing to fight to make those words mean what they should mean that has given it the rich meaning that it holds today. And you also know that that struggle is not over. We have lawyers here from the NAACP Legal Defense Fund, and if you're here, could you just wave your hand? And this is just a fraction of our staff, but we are never out of work. And the principal tool that we use is the 14th Amendment. And so that shows you that the struggle is not over. Whether we're talking about voting rights or education or economic opportunity or criminal justice, the 14th Amendment remains central to the struggle for full equality and citizenship for African Americans and others in this country. Before I take my seat, I just want to remind you about the fact that you're going to hear a lot today from some of the most extraordinary and brilliant scholars, 14th Amendment scholars in the country. But I don't want us to forget the role of average, ordinary people. Just a few weeks ago, I had occasion to speak at the memorial service for Linda Brown. Linda Brown was the little girl in the family that took the courageous step of being willing to be the lead plaintiffs in Brown versus Board of Education. And Brown versus Board of Education decided in 1954 did as much to reset and reimagine the meaning of the 14th Amendment and fulfill the promise of the 14th Amendment as any case that has ever appeared before the Supreme Court. And so today, when we talk about cases and when we talk about interpretations and when we talk about Supreme Court justices, I also want us to remember a little girl and her family and the other families in the other cases that made up Brown versus Board of Education, who made the sacrifice of exposing themselves in their community, sometimes to violent reprisals, in order to fight for the reality of the words of the 14th Amendment for you and for me, not just for themselves. These are extraordinary American patriots, and they made tremendous sacrifices for all of us. So today, let's certainly talk with these extraordinary scholars, but let's not forget that the ability to give our Constitution real meaning comes through the courage of average, ordinary people like Linda Brown, Oliver Brown, and the plaintiffs in that extraordinary case. Thank you for being with us today, and I look forward to listening to this first panel. Thank you, Jeffrey.
Wonderful. Thank you again, Sherrilyn, for your vision and enthusiasm in convening us. Ladies and gentlemen, our first panel is about the history and original meaning of the 14th Amendment. The second panel is about its public meaning and social significance, and the third panel is about its contemporary relevance to our lives. You're about to hear from the greatest historians in America about the original meaning of the 14th Amendment. I'm going to introduce them, and we're going to begin our discussion. Allen Guelzo is the Henry Luce Professor of the Civil War Era and Director of Civil War Era Studies at Gettysburg College. His most recent book, released earlier this month, is Reconstruction, A Concise History. Martha Jones is the Society of Black Alumni Presidential Professor and Professor of History at the Johns Hopkins University. She is author of All Bound Up Together, The Woman Question in African American Public Culture, and most recently, Birthright Citizens, A History of Race and Rights in Antebellum America. And her work, I was so honored to learn, began here at the Constitution Center when she was a fellow about a decade ago. Kurt Lash is the E. Claiborne Robbins Distinguished Chair in Law and the founder and director of the Richmond Program on American Constitution at the University of Richmond School of Law. His books include The 14th Amendment and the Privileges or Immunities of American Citizenship. And Kurt is engaged in an incredible project to digitize all of the Reconstruction era congressional debates, and the Constitution Center is so excited to work with him to bring those crucial debates to all Americans. And Darrell A. H. Miller is Melvin G. Shim Professor of Law at Duke University School of Law. He is published in leading law reviews and has been cited by the Supreme Court of the United States. Please join me in welcoming Allen, Martha, Kurt, and Darrell. Wonderful. This is great. If I can ask you each to shift over one so I can sit here and see you all, I am going to begin this very important panel by reading the text of the 14th Amendment. And there are lots of places where you can get it, but one of the best is the Constitution Center's Interactive Constitution, which has the leading scholars in America writing about what they agree and disagree about every clause of the Constitution. Ladies and gentlemen, I'm so excited. We've been waiting for Akil Amar and John Harrison to turn in their homework for the final, for the Citizenship Clause and the Privileges or Immunities Clause, but Akil just sent in his explainer this morning in honor of the 150th anniversary of the 14th. It'll be online later this week, I hope, but and you can check it out then. So I'm going to read the section 1, and then we're just going to discuss its clauses and their history and original understanding. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That's called the Citizenship Clause. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. That's the Privileges or Immunities Clause. Nor shall any state deprive any person of life, liberty, or property without due process of law. That's the Due Process Clause. Nor deny to any person within its jurisdiction the equal protection of the laws. That's the Equal Protection Clause. Now, entire law school seminars and courses are taught over each of these clauses and each word, and there's so much to learn and unpack, but we want as intensely and meaningfully as possible to understand what the framers were trying to achieve with these clauses. And Allen, I'm going to begin with you, and I'm going to ask you about the citizenship clause. And if you, I think I'm going to leave it up to you. If you want to give a global, brief description of what the entire Section 1 was trying to achieve, or if you want to start with citizenship, that would be it.
Well, citizenship is an unusual subject because the Constitution actually does not, in its original form, give us a definition of what citizenship is. There are 5 references to citizenship in the Constitution, and some of them refer to citizens of the states, some of them refer to citizens of the United States, but the 2 categories are not distinguished. They're not even defined. And for that reason, there's a cloying lack of clarity about this in the early decades of the history of the Republic. It comes to a point, though, with the Dred Scott decision of 1857, because in that decision, Chief Justice Taney takes the bolt between the teeth and decides that he is going to define citizenship, or at least what he's going to do is define who can't be a citizen. And clearly and unambiguously for him, you cannot be a citizen if you are a black human being. Not just a slave, not just a free, no, if you are a member of that race, if you are that color, you cannot under any circumstances be a citizen. What he's doing is defining citizenship according to a standard that we call jus sanguinis. In other words, the law of blood. You have to be of a certain descent to enjoy citizenship. What happens with the Civil War is a complete overturning of that. And to codify that overturning and to put a new definition of citizenship in place, what the 14th Amendment does, and especially in the hands of John Bingham, one of the architects, principal architect of the 14th Amendment, is to redefine citizenship. It's to rebuke, it's to reply to Chief Justice Taney in Dred Scott, and to say, no, the basis of citizenship in the United States is you are born here. It is jus solis, the law of the place where you are born. So if you are born in the United States, you are a citizen of the United States. That is a remarkable departure, because for the first time, we are getting a definition of what citizenship is supposed to be, and there it is in the 14th Amendment. So the 14th Amendment then acts to correct, first of all, the oversight of the original drafts of the Constitution in not defining citizenship, but more directly, it speaks to a correction of Roger Taney in Dred Scott. And it lays out for us now what citizenship in the United States is supposed to be, makes it clear that this is the paramount loyalty which Americans have. You may be a Virginian, you may be a Minnesotan, you may be from New Jersey, you may be from Florida, but your primary identity is that of a United States citizen. And from that point through Section 1, we also learn what being a citizen of the United States entails. But that's enough from me for the moment. That in enough. If the 14th Amendment only did that one thing about citizenship, it would have completely moved the earth in terms of legal standing and in terms of what the Civil War had accomplished.
What a beautiful and concise description of the purpose of the Citizenship Clause. You've told us that it was meant to repudiate the idea of citizenship based on blood and to embrace an idea of birthright citizenship, and to overturn the Dred Scott decision, which embraced the blood rather than the birthright vision. Martha, in your new book about birthright citizenship, you explore precisely this question. What were the consequences of Taney's Crabb definition of citizenship based on blood for African Americans before the Civil War, and how did the 14th Amendment correct that notion by embracing the idea of birthright citizenship?
I think in order to fully understand the import and the consequence of the citizenship provision of the 14th Amendment, we have to go back in part to where Sherrilyn Ifill brought us in her opening remarks, which is to ordinary people. So here, former slaves who have been a part of the nation to an important degree since the American Revolution have faced a question that is now an enormous one. Who are they in relationship to the nation? Who are they in relationship to the Constitution? And when we look back, to their activism, to their debates, what we learn is that since the 1820s, former slaves had been contemplating, debating, crafting an argument about their status as birthright citizens. They draw on that tiny language in the Constitution. You all will remember this, right? The president must be a natural-born citizen of the United States. And they seize on this, and they say, there is such a thing as a natural-born citizen, and we are, right? The Constitution is silent about race, and we are natural-born citizens. Why is this important for Black Americans? Well, there's an important story that I'm sure we'll get to today about civil rights and political rights. But what former slaves faced before the Civil War is something else. And it is a threat of removal, of banishment, of exclusion from the United States. This comes in the form of what we call black laws that regulate in a quotidian way their lives. It comes in the form of colonization schemes where private organizations command resources intended to encourage, sometimes quite forcefully, African Americans to relocate to Liberia or to Canada or to the Caribbean. And so former slaves watch the example of Indian removal, and they are concerned that they are going to be subject to the same sort of fate. And they hope, they believe, they argue that birthright citizenship and that status is what will protect them. So we have, by the time we get to the moment of the 14th Amendment, a sort of culmination of really decades of activism, of argument, of contestation driven by the claims of Black Americans, that now their view of their status as birthright citizens is constitutionalized in 1868. And so it's a tremendous moment.
You so powerfully describe, as you argue in your book, how the fear of deportation was so acute and how the current debates about deportation relate to these Civil War era ones, where citizenship guarantees you the right not to be sent from America and to be guaranteed the basic rights of citizenship. Kurt, you can say more about the Citizenship Clause if you like, but you are also America's leading scholar of the Privileges or Immunities Clause, along with many of your colleagues here. And the Privileges or Immunities Clause says no state shall deprive any citizen of the privileges or immunities of citizenship. So begin to tell us, what are those privileges or immunities of citizenship?
Indeed, and the Privileges or Immunities Clause is one of the most debated portions of Section 1, and I do want to talk about it, but before we get there, okay. Just a quick comment on the Citizenship Clause. Jeff began by reading the portions of Section 1, and all he's given you is just that opening section. If he had read the entire 14th Amendment to you, he'd still be going right now, and we wouldn't be having this conversation. It's an extraordinarily long and complicated set of 5 provisions, and we're just starting on the opening sentence on citizenship. And putting this 5-section amendment together was extraordinarily difficult. It was an amazing battle that occurred in the opening months of 1866. And the Citizenship Clause, in fact, was the very last addition, a last-minute addition to Section 1. And it started not as a proposed constitutional amendment. The Citizenship Clause began as a statute. It's the opening language of the Civil Rights Act of 1866. What happened is when the 39th Congress met, soon after the ratification of the 13th Amendment, the members of the 39th Congress had something of a political emergency facing them that I know that Allen and others are going to want to talk about. But to solve the emergency and the protection of rights in the South following the end of the Civil War was going to take some type of legislative action, and they were actually divided over whether or not to do it by way of statute or do it by way of an amendment. The Senate began with proposing statutes, an extension of Freedmen's Bureau Bill and the Civil Rights Act, what became the Civil Rights Act of 1866. In the House, they discussed amendments, and men like John Bingham got to work on protecting various individual rights and due process rights and equal protection rights. Everyone in both the House and the Senate was proposing multiple statutes, multiple amendments. There was chaos all the way until I think around April of 1866. They could not find agreement on how to approach Reconstruction or how to put together the proper language of Reconstruction. And it wasn't until about April that they finally decided to bring all the ideas together into this 5-sectioned amendment. And the opening section was going to be written by John Bingham, who had started with ideas of privileges or immunities and due process and equal protection. But Representative Bingham did not have a citizenship clause in his proposal. He had certain concerns about protecting the Bill of Rights, so there's my answer to the privileges or immunities question. He very much wanted the Bill of Rights applied against the states for the first time. It had not been true since the time of the founding. But he was not part of the efforts that had crafted or supported the Civil Rights Act of 1866. So at the last minute, due to concerns that that courts might decide Congress didn't have power to pass the Civil Rights Act of 1866, including the citizenship clause, a suggestion was made to add an additional sentence to Bingham's amendment just to make sure that this would not be overturned either by a new Congress or by the courts of law. So this very first sentence was the last addition.
Fascinating. Darrell, Kurt just alluded to the emergency that gave rise to the amendment, including the black codes that denied African Americans the right to make or enforce contracts, to sue and be sued, to inherit property, and to take advantage of the basic civil rights of white people. And as he mentioned, the Civil Rights Act of 1866 guaranteed to all citizens, black as well as white, the rights of basic civil rights. Tell us about the Black Codes and the Civil Rights Acts of 1866. What was going on the ground, and how did the 14th Amendment intend to ensure that the rights of the Civil Rights Act were constitutionalized?
So the situation on the ground right after the Civil War was pretty dire. There were reports by individuals like Carl Schurz who went down to investigate what was going on in the immediate post-war period, how things were going, and what he reported back was pretty grim, especially for the newly emancipated freedmen. They were basically caught in a whipsaw between private discrimination and public discrimination. So what would happen would be that there would be laws, for example, that would say that one was a vagrant and could be picked up and charged with a crime of vagrancy if one did not have a job or own property. And yet the situation was that the whites who actually owned property or who could hire African Americans would not do so except on the terms that were created by either the Black Codes or the old slave system itself. For example, somebody might try to go off their plantation to work at another farm, and somebody would say to the effect of, who do you belong to? You can't work for me unless they say it's okay. Then freedmen with no job and no property would be picked up by the local officials and charged with a crime. And then the 13th Amendment has an interesting loophole, which essentially says that involuntary servitude is outlawed. Slavery and involuntary servitude are both outlawed except as punishment for crime. So having been picked up for having no job and having no property and duly convicted, then the freedmen would be sold at a sheriff's sale as convict labor, and a kind of vicious circle would emerge. And so in part what the Civil Rights Act of 1866 was designed to do was to break this sort of unholy alliance between private discrimination and public discrimination, and used the metric of the privileges, the powers, the rights that white citizens had as the metric for all citizens, and in fact said very expressly that freedmen should have the same rights as are enjoyed by white citizens to own property, to be able to contract. The idea to break up what was essentially a kind of cartel behavior on the part of private power brokers in the South. And then on sort of parallel tracks, there was anxiety about what the Civil Rights Act of 1866 did, both in terms of its substance and in its terms of describing citizenship, and this gave rise to the need among some members of the Congress to work on an amendment that would make sure that this was not just a statutory guarantee, but could be insulated from, as Kurt had said, overturning by a court or repeal by a subsequent Congress.
Great. Not great, but well described. The opposite of great. But great that the Privileges or Immunities Clause attempted to apply the Bill of Rights against the states. As Kurt said, before the 14th Amendment was passed, the First Amendment says Congress shall make no law. It doesn't say the states shall make no law, and therefore the states were free in the antebellum period to deny free African Americans the right to denounce slavery, to send their pamphlets through the mails, and to enjoy basic privileges or immunities. So as Kurt has argued so powerfully, one goal of John Bingham, the James Madison of Reconstruction, was to prevent the states, as well as the federal government, from abridging the basic liberties of the Bill of Rights. Allen, there's a big controversy from much of the 20th century about what else the Privileges or Immunities Clause covers. Some say that it's just an equality provision and says that whatever rights the states extend to white citizens have to also be extended to blacks. Others say that it includes certain substantive rights, not only the Bill of Rights, but also those rights in the Civil Rights Act of 1866, like the rights of contract and property and so forth. What do you think that the Privileges or Immunities Clause was intended to protect?
Well, at least as far as John Bingham has told us, we get some very contradictory readings. Bingham wanted to model the reference to privileges or immunities to the Privileges and Immunities Clause that appears in Article 4 of the Constitution. That in itself had been a source of legal controversy because the assumption had been that all that privileges and immunities was being described in the Comity Clause in Article 4 was simply just saying, well, if a certain person moves from a state to another state, the state to which they have moved cannot arbitrarily prevent them from enjoying the same privileges that someone in that state to which they've moved enjoys. In other words, if I move from Pennsylvania to New Jersey, the governor of New Jersey cannot say, I really don't like people from Pennsylvania, so therefore I am going to tax you at a higher rate than New Jersey citizens, or I'm going to prevent you from practicing certain professions in New Jersey because you're just a Pennsylvanian. And there are certain shops at the Jersey Shore which have made me feel that way. But the understanding was that the Comity Clause was there to prevent that from happening, so that if you practice law in Pennsylvania, you can go to New Jersey and you can practice law there. If you have a profession that you practice at home, you can move to another state and practice it there. The states cannot deprive you of that. They cannot create artificial burdens to prevent you from doing that, because that would be to interrupt the comity. And comity, of course, had been a major question in the creation of the Constitution itself. I mean, in a sense, the Constitution, if you go back to the Annapolis Convention, really begins with discussions about comity, about how do the states deal with each other? Do they tax each other? Do they impose tariffs on each other? So in one sense, what Bingham aimed to do was, at first at least, only to act as enforcing this notion of comity. But as soon as he gets into it, the ground begins to shift. And he begins to want to talk about the enforcement of the Bill of Rights. In this case, by and large, the first 8 amendments to the Constitution. So that he talks about something different from what the Comity Clause talks about when he says in the 14th Amendment, the privileges or immunities of citizens of the United States. Right? Suddenly we're dealing with a different category. Now, what is that category? Well, Bingham believed that that category was the first 8 amendments. Sometimes he will talk about it in even more diminished terms, as simply life, liberty, ownership of property. Over time, we have expanded that. We have included a number of substantive rights. We're still debating that. But at least as far as Bingham's original view of things, it tends to oscillate between, is he just talking about enforcing comity? Well, that is part of it. Or is he adding to that by saying, citizens of the United States, well, that means first 8 amendments to the Constitution, to the Bill of Rights, that states cannot abridge those. Certainly in Bingham's view, it doesn't go beyond that, but there will be later decisions and later controversies and a history which will generate a very different kind of jurisprudence.
That's very helpful to sketch out the difference between the equality vision of the comity clause and the incorporation of the Bill of Rights.
Can I say one thing? Sure. You know, this sounds like we got into the weeds really quickly with this, and that it can sound like, why didn't they just make this simple?
Yeah.
And there's a fundamental reason for that, and that is there is no such thing as a reference book called Reconstruction for Dummies. You know, they did not get to the Civil War. General Lee didn't walk off the porch at Appomattox, and everyone said, okay, now we know what to do. Let's implement phase 1 of Reconstruction. At that point, it was like, what's a phase 1 of Reconstruction? There was no model for how to do Reconstruction. So there's a very large sense in which Reconstruction really looks like improv, that no one knew what to do next. And it's something like the little Dutch boy plugging the holes in the dike. Let's put a finger in that hole. Whoops, there's another hole. Ooh, let's put another finger. And they're trying to deal with situations as they arise. When Kurt was talking about all the things that are really packed into this 14th Amendment, I mean, not just privileges and immunities, but talking about the Confederate war debt, about who is entitled to occupy certain offices, representation. What the 14th Amendment is really doing is offering you a map of the controversies that had exploded in the years since the end of the Civil War, and which people were trying to find a way to cope with. And the truth of the matter is that even after they're finished with the 14th Amendment, plugging up at least 4, 5, maybe 6 or 7 or 8 of those important questions, suddenly they have to turn around and realize, ooh, we forgot to deal with a few other things. Hence the 15th Amendment that will come further on down the pike. So bear in mind, if a lot of this sounds like people aren't getting their ducks lined up, it's because there was no line. In fact, they didn't even know they were dealing with ducks. You know, Reconstruction is terra incognita, and they are trying to work through these problems. Congress, in this case particularly, are trying to work through these problems as they're being brought to their attention, and they just don't have templates. They don't have books of instructions easily at hand to guide them in what they should do next.
Well, one of the consequences of creating holes that had to be plugged was that the Privileges or Immunities Clause was eviscerated by the Supreme Court. And as every law student knows, in the infamous slaughterhouse cases, the Supreme Court held that privileges or immunities were a narrow category of rights already protected by the existing Constitution, like the right of to file suits in admiralty on the high seas and so forth, basically reducing the clause to a nullity. Martha, what were the consequences of the evisceration of the 14th Amendment in the slaughterhouse cases? And how did the other clauses of the 14th Amendment come to take up the slack?
It's a great question because the first thing that comes to mind, right, is the slaughterhouse cases as really representing the moment of deep disappointment, right? Deep disappointment in the promise of the 14th Amendment, the possibility that the Constitution, that the federal courts, that the federal government will serve as a guarantor, right, in an important sense of not only the rights of former slaves, but the ongoing, right, process of what is answering what is freedom, right? How is freedom embodied, not only in a constitutional sense, in a lived sense every day. So we can sort of characterize this moment as a moment, a turning point, as a point of disappointment. I would say one of the things that happens for African Americans, right, is to return, interestingly, to struggles on a state and a local level, right? As increasingly the signs are, right, that the Supreme Court is not going to be a guarantor of rights, is not going to be an ally in this long process of freedom. And so the people I study are, I think, not quite in the haphazard way that Allen suggested, but in a very deliberate way, always experimenting with the possibilities at the federal level and at the same time in state and local venues.
No, I'm talking about members of Congress.
Yes, absolutely. So it's to say, my folks, I think, have a strategy, right, rather than a scattershot approach, and they are going to be looking to allies in state and local courts, for example. They are going to be looking back to the texts of what are new state constitutions. They're going to be looking at that level for the possibility of, in a sense, actualizing what it is, the best promise of the 14th Amendment.
Kurt, how big a deal was the slaughterhouse cases? Why did it come out the way it did? Did it reflect the changing politics of the time, or was it a legitimate legal disagreement? And then tell us about how the Due Process Clause of the 14th Amendment did come to take up some of the slack that the slaughterhouse cases created.
The slaughterhouse cases, I teach constitutional law at the University of Richmond School of Law, and the slaughterhouse case takes up a major portion of that course because it represents in many people's mind a lost opportunity for the court to enforce the 14th Amendment against the states and protect a body of rights that men like John Bingham had hoped were going to be now made applicable against the states. And my students are often surprised by the very issue, because many of them come to my classes not knowing that the original Bill of Rights only bound the federal government. It was passed by the original Congress, drafted by the original Congress and ratified very quickly after the original Constitution, and it only required the federal government not to establish religion. It only applied Fifth Amendment due process rights against the federal government. States remained free to determine for themselves how they were going to approach criminal procedure, or how they were going to protect freedom of speech, or whether or not they were going to have slaves. And it was during the period between the founding and the time of the Civil War that this idea that certain critical subjects involving human freedom should be left to the states came under severe questioning. The evil of slavery became wrapped up more and more in politics, and drove discussions in politics that slavery was something, at least in the people of the North, could not accept, particularly because it seemed to be against this fundamental idea of due process in the Fifth Amendment, that no person should be deprived of life, liberty, or property without due process of law. And whatever the culture at the time thought about blacks as citizens, they certainly couldn't deny that blacks were persons. And so the abolitionists began to create this rhetoric of freedom based upon one of the provisions in the Bill of Rights. And it drove an idea that that bill should not only represent something binding upon the federal government, it's something that all of us should be protected from, whether it was a state official who was depriving us life, liberty, or property, or a federal official. So there was a growing idea that these rights should be nationalized, should be made applicable against the states, and certainly John Bingham had hoped that that would be an accomplishment through his demand in Section 1 that no state shall make or enforce any law abridging the privileges or immunities of citizens of the United States. Nor shall any person be deprived of life, liberty, or property. But in Slaughterhouse, the court took an interpretation. It's a few years after the ratification of the 14th Amendment. And the court views the main provisions of Section 1 in ways that scholars have criticized as unduly narrow, as not including certain economic rights, certain labor rights. And when he came to describing privileges or immunities, it was almost as if he was saying that nothing had changed by the adoption of the 14th Amendment. He didn't spell it out in that case. It was Cruikshank, a few years down the road, that just came right out and said, those Bill of Rights that you might have thought would be applied against the states are not privileges that will bind state action. And so the Privilege and Immunities Clause, very shortly after its ratification, disappeared from the stage in terms of being one of our protected rights. The semi-happy ending comes in the late 1800s and into the turn of the 20th century, when the Supreme Court begins to develop its idea of what counts as due process. The idea that certain liberties should not be denied no matter what kind of process has actually been provided. And the court begins to develop a collection of due process rights, it's sometimes called substantive rights, whereby no matter what kind of process is provided, you still should not have your property taken without just compensation. And you should still be protected in your freedom of speech against state officials shutting down your assembly or shutting down your expression. And one by one, they begin to treat due process liberties as if they have incorporated rights originally listed in the Bill of Rights. And that, in fact, is the court's approach to this day. John Bingham's original vision of applying Bill of Rights against the states is currently substantially the law. It just occurred by way of the Due Process Clause and not by way of the Privileges or Immunities Clause.
Wonderful. So just to review, everyone, this is very wonky but really important. John Bingham had hoped to ensure that no state could abridge the rights of the Bill of Rights, and he said that in the Privileges or Immunities Clause, but the Supreme Court interpreted that clause in a way that reduced it to a nullity, and as a result, the Supreme Court, starting at the turn of the century, but not really culminating until the 1960s and 70s. It took almost 100 years to make Bingham's vision a reality, used the Due Process Clause of the 14th Amendment to say there are certain basic liberties that can't be abridged by states as well as the federal government. Darrell, let's return from this very technical law to the historical context. Why did the court eviscerate the clause after the high water mark of Reconstruction? What happened in 1876 to end the commitment to Reconstruction, and describe what was happening on the ground in the 1870s and 80s to reduce the promise of Reconstruction to a nullity?
So let me start, and I'll come full circle on it, because I disagree, I think, a little bit with what Allen said about there being no model. There was a model for what to do, but it's one that nobody wanted to really touch, which is the law of conquest. That is, from antiquity onward, the penalty for losing a war of rebellion was that all the leadership were executed or enslaved. In fact, the fact that many Africans had been caught in warfare was justified, their slavery was justified as the law of conquest. And so there was a model, but it was just so, it was such a strong medicine and created such an intellectual problem with the nature of the Civil War. What were the states in rebellion? Were they no longer states? Were they still states but sort of misbehaving states? That as a matter of practice, it was not triggered. So there was a model, but it wasn't one that the Reconstruction Congress felt very comfortable in using to its full extent. Now, how does that lead to what happens in the waning of Reconstruction? Well, in my civil rights litigation course, which I teach, I often give my students this sort of set of particulars on the ground. You have millions of freedmen. They don't have a lot of education. You have a hostile southern populace that resent the fact that there are many freedmen in their midst. And you also have eventually a kind of waning attention on the part of northern advocates. And so I think it's fair to say that part of the sort of the reason why, for example, the Privileges or Immunities Clause is sort of sapped of its power, part of it is legal, but part of it is an eventual sort of weariness with what to do about Reconstruction, when are things going to be back to normal? When are we all going to be just states again? When are we not going to have to worry about the freedmen anymore? And so I think, from the 30,000-foot view, the reason why the cases end up eventually sapping the 14th Amendment, at least in some respects of its power, is sort of following the election results, as they say, with respect to interest in the Reconstruction project as a whole.
Let's take one round on the word that is the center of our symposium today, but we haven't focused on yet in this panel, and that is equal protection, equality. And then we have some great questions from the audience. Allen, the 14th Amendment says that no state shall deprive any person of the equal protection of the law. The core meaning of protection was that white mobs can't set on African Americans and the police refuse to respond and they're denied physical protection. And yet, that mob violence was tolerated. Congress forbade discrimination and quasi-public accommodations in the Civil Rights Act of 1875, but the Supreme Court struck that down in the civil rights cases. So give us a brief history of the rise and fall of constitutional equality, and why was the framers' hopes on that scores thwarted as well?
Equal protection will rise and fall almost in direct parallel with the rise and fall of privileges or immunities. Because equal protection, first of all, is going to get qualified by who is protecting whom. Does the federal government have an obligation, does it have an opportunity to intervene in providing equal protection? Well, under what circumstances? One of the most dramatic circumstances involves a major race riot which takes place in Colfax, Louisiana in 1873. And it was a case where a white mob set upon black electors at a courthouse and massacred them. I mean, there's no better word to use. You can't gentrify it in any other way. It was a massacre. When this finally comes up to the United States Supreme Court, it's the case we sometimes know simply as Cruikshank versus U.S., Cruikshank having been one of the members of the mob. The United States Supreme Court backs off from this because, and its answer is twofold. One is it says, first of all, the Constitution and the intention of the 14th Amendment is only to restrain the states. Now that was actually a step in the right direction when that was originally conceived. However, in Cruikshank, the judgment that is made is that, well, this was a white mob, it wasn't the state of Louisiana. Since it wasn't the state of Louisiana organizing the white mob, therefore, there's no obligation on the part of the federal government to step in and provide anything that could be called equal protection. It sounds to us like they were in 1875 when this decision is finally handed down. It sounds like they're really parsing this in a very narrow, focused way. And in fact, they were. But they were also doing this according to this notion of what level of obligation brings in the federal government. Well, if it was the state which had done this, all right, fine. But it wasn't the state. No one can show us that the state actually set this situation up. This was the spontaneous act of a white mob. Therefore, the federal government doesn't really have any role to play in dealing with this. In a way, you back off from that and you say, wait a minute, this was a mob action, there was a massacre. Somebody's got to do something about something here. But the response of the Supreme Court was, yes, but not us. Not us. It's not our obligation, and not even the 14th Amendment with equal protection obligates us, because the only thing we provide equal protection for is against actions done by the states and state governments themselves. So if the state of Louisiana had gotten up this massacre, oh yes, then perhaps in theory the Supreme Court would have gone into full mode. But they can back off on this and say, well, you know, it's really not our problem because it wasn't organized by the state. And that becomes the basis for the Cruikshank decision, and actually becomes the basis really for emptying the 14th Amendment and the Equal Protection Clause of a lot of its effective application. I mean, it's a horrible decision in a horrible case. And it brings forth all the head shaking that we ought to have over good logical reasoning from bad premises to bad conclusions. You know, if you start off with bad premises, you can have all the wonderful legal logic in the world, but it'll still give you bad results. That still doesn't mean it was respectable. We've spent a long time since Cruikshank trying to claw back from that.
Martha, I'm going to ask you what you make of Cruikshank, the civil rights cases, and the evisceration of the promise of the 14th Amendment by the Supreme Court. Why did the court parse the amendments as it did? Were they bad originalists or motivated by an animus to Reconstruction? And then I'm going to put on the table this excellent question from the audience as well. What did the 14th Amendment mean for those African Americans who came here before it was ratified, but owned land and other property? What happened to their property? What rights did they have?
So maybe I'll try that in reverse order.
It's two big questions, but thank you.
And say that the second question really picks up on the long story of the 14th Amendment, which is that free Black Americans have indeed been engaged in attempting to protect their property and their persons by way of local courts for a very long time before we get to the 14th Amendment. So there is an awareness, not only on the local level in the lives of Black Americans who are building families, homes, communities, churches. All of that requires many things, but it requires law, right, to do and to do well and to sustain. So we have that level. And at the same time, we've had, over the course of 30 years, state high courts, which have really vacillated around the degree to which they are going to protect those civil rights for African Americans. So it's a tremendous moment. It's a tremendous moment of possibility, right, when the 14th Amendment is now going to constitutionalize, right, and has the possibility, the promise of now overseeing state legislatures, state courts, and guaranteeing these kinds of rights that African Americans have piecemeal, but in an important way, been securing for themselves over time. I have to take us all the way, if I could, to Plessy versus Ferguson, because I don't think we can talk about equality without talking about Plessy and appreciating, for most of you will remember that Plessy is the case that leaves us with a dark legacy of the notion of separate but equal, examining the organization and the regulation of streetcars in the state of Louisiana and the city of New Orleans. This is a challenge that is brought by a next generation of African American legal activists, now with a new set of tools and a new kind of access, a new kind of organization, still thinking hard about the Constitution and its promise. And the logic in Plessy, right, which says, indeed, yes, Black and white patrons on streetcars must sit in separate sections. Nothing unequal about that, right? Because everyone gets to ride, and Black and white patrons are treated in the same way because they're separated. Well, for me, that strained logic, right, tells us a lot about where we are with the court by the time we get to the end of the 19th century. There's no secret, right? There's no deep probing required to appreciate, as Homer Plessy argues, right, that the separate requirement is intended to denigrate, to mark African Americans as different, as inferior, as somehow not citizens equal to their white counterparts. This is not a secret logic or a mystery for a Supreme Court that nonetheless is prepared to twist that notion of equal and leave us with a legacy that we continue to grapple with, I think, until today.
Thank you for putting Plessy on the table and describing it so powerfully. We're going to have some thoughts from Kurt and then Daryl and then wrap up. So Kurt, during his confirmation hearings, Justice Neil Gorsuch said that Plessy was wrong the day that it was decided as a matter of original understanding. Was it wrong the day that it was decided, and what do you make of the court's evisceration of the promise of Reconstruction?
Plessy and Cruikshank and these series of decisions that come down by the court that left Blacks defenseless against private violence, not just against state violence, but against private violence, is the story of the great tragedy of failure, both political failure, both majoritarian failure, but also judicial failure, to invoke and enforce the protections of the 14th Amendment. And that's why so many of the discussions of the history of the 13th, 14th, and 15th Amendments are stories of tragedy, of stories of failure. But before getting there, notice what we're talking about. We're talking about a failure to enforce something. What is it that they failed to enforce? Well, there's an amendment back there that somehow got passed, somehow got added to our Constitution, which declared principles that then were going to stand in judgment against later generations, including later generations of courts. And before we too quickly get to the story of tragedy, and there is a story of tragedy, I think there's also a story to celebrate regarding why these principles were added to the Constitution in the first place. And this also goes to your initial question of how did we get it and the meaning of the Equal Protection Clause. We almost didn't get it. It was once Congress drafted this complicated 5-sectioned proposed amendment to the Constitution, nothing like it had ever been on the table before. The country erupted into political controversy over whether or not this was an appropriate restructuring of the American Constitution. And it was a reversal of the idea that you could best trust local politicians to take care of you. That's why the original Bill of Rights only bound the federal government. It was federalism. We trust people who we know, right? Well, after the experience with slavery and the experience with the suppression of rights of both whites and blacks in the South, we adopt these amendments, or at least we put on the table this idea that maybe some of these rights aren't being protected by state officials. But it wasn't clear that the nation was going to buy it. In the months between June, when it's first sent to the states for ratification, for the first 6 or 7 months, the Democrats raise a powerful argument that this is an unreasonable expansion of national power, that this is going to create a tyrannical Congress who's going to try and take over all of local laws. They're going to be unaccountable. It'll be worse than King George III. But midway through the summer, something happens which actually turns the country, particularly the North, in the direction of the 14th Amendment and the Equal Protection Clause. And it takes us back to Louisiana again. A group of freedmen had gathered in New Orleans to discuss amending the state constitution to give them the right to vote. That assembly was targeted by local mobs under the direction of the mayor of New Orleans. They attacked the assembly, started shooting the members of the assembly, and when they tried to surrender, they shot them dead anyway. It became a national scandal. There was probably no more reported event that occurred from summer to the end of 1866 than the riots of New Orleans. What happened at this point is that the Democrats who were fighting against the 14th Amendment, including Andrew Johnson, the President of the United States, they had argued we didn't need a 14th Amendment. You could trust state officials with your privileges or your immunities. You could trust them to equally protect all persons in their lives and their property. The Republicans simply pointed to New Orleans. And what had been an even bet as to whether or not Republicans were going to be elected in 1866, instead the country in a landslide re-elected Republicans and defeated Democrats, voting in what actually became a referendum on the 14th Amendment that in fact we could no longer trust state officials with our most important rights, our most important privileges and immunities, and the idea that we would be equally protected in our lives and property. That was the vision that the country decided to make a part of their Constitution in 1866, and the Republicans got it done. It then becomes a judgment onto later generations as to whether or not we lived up to that initial vision. But there was a point when the country knew it, and the country embraced it and made it a rock that maybe it took too long to get to, but eventually courts did. And it was that rock of equal protection that the most important decisions of the Supreme Court of the 20th century are based.
Thank you for that. Darryl, the last word is to you, and the question from the audience is about the role of African Americans in Reconstruction. How does W.E.B. Du Bois's scholarship in Black Reconstruction stand up today? How much do we owe to his research? And tell us about other African American unsung heroes of Reconstruction who helped make the Reconstruction Amendments a reality.
It's a great question. So I think it's fair to say that what happens in the Reconstruction period and afterward is that there is a revision of history. It's sometimes called the Dunning School of scholarship about the South, in which Reconstruction is portrayed as a wildly misguided mistake, that it was all kinds of unqualified individuals ruling the states and going to Congress. It was all kinds of graft and corruption. And that's all that can be said of Reconstruction. And in fact, it was a redemption. They were called redeemers, were the Southerners who ended up taking over in the South and redeeming it from this sort of corrupt period of time. And what Du Bois did was question that Dunning school of thought. Said, no, this is an effort to portray a constitutive point in our past as something that is less, something that is a mistake, and we shouldn't accept it. It's taken generations for the Dunning School of scholarship about Reconstruction to finally be laid to rest, and occasionally you'll see versions of it pop up. But in sort of trying to lay that school of scholarship about Reconstruction to bed, the participation of African Americans in their own power centers, in their own making constitutive of the nation has really been an important part of that story. Whether you're talking about some of the first lawyers, African American lawyers to ever attain the bar, or you're talking about individuals who risked their lives to run for office and become the first African American office holders. And recapturing that story has been important. And I think it's also important to realize, and this is one thing that I want to sort of leave you with, that there's a through line. It's a through line not only from the 14th Amendment, but 100 years forward into the what is sometimes known as the Second Reconstruction, which is the Civil Rights era. The same type of arguments, that African Americans are citizens, that they deserve protection, they deserve respect, is the same kind of arguments that are made 100 years before and are made on the steps of Washington and on the Edmund Pettus Bridge 100 years later.
This has been a superb introduction to our important day of discussion. To keep on schedule, I'm going to ask you to stay in your seats, and Sherrilyn will come out in a moment to begin our next panel. Please join me in thanking our wonderful panelists. Excellent. Wonderful. Doing great.
Thanks.
Thank you. Very substantive, very meaningful. It was. Great. Thank you. Excellent. It's good to have that.
We never got to talk about Andrew Johnson.
I think, like, I can't believe that was over.
There's so
I feel like I had a long
I
list
know.
of things.
right, I think we're good. Terrific. Okay. Great to see everyone buzzing and talking after that terrific first panel, but it's time for our second panel, which is entitled Reconstruction, America's Second Founding and Public Memory. And we have three terrific and distinguished panelists who are going to lead this discussion with us, and I'd like to introduce them to you as they come out. Eric Foner is the DeWitt Clinton Professor of History at Columbia University. He specializes in the study of Civil War and Reconstruction, slavery, and 19th century America. His seminal work, I'm now reading off the script, Reconstruction, America's Unfinished Revolution, 1863 to 1877, is my second Bible on the Reconstruction period after W.E.B. Du Bois's Black Reconstruction. These two books, if you want to understand this period, in fact, if you are an American and a scholar of American history, you should own these two books, W.E.B. Du Bois's Black Reconstruction and Eric Foner's Reconstruction, America's Unfinished Revolution. He's one of only two persons to serve as president of the Organization of American Historians. American Historical Association and Society of American Historians. He's been the curator of several museum exhibits, including the prize-winning A House Divided, America in the Age of Lincoln at the Chicago Historical Society. His book, The Fiery Trial, Abraham Lincoln and American Slavery, won the Pulitzer, Bancroft, and Lincoln Prizes for 2011, and his latest book is Gateway to Freedom, The Hidden History of the Underground Railroad. Kate Masur is an historian of the United States, examining intersections of law, politics, and everyday life. Her scholarship explores how Americans grappled with questions of race and equality after the abolition of slavery in both the North and the South. Masur is author of An Example for All the Land, Emancipation and the Struggle over Equality in Washington, D.C., and numerous articles on emancipation and Black politics during and after the Civil War. With Gregory P. Downs, she recently co-edited really a wonderful collection of essays, The World the Civil War Made, which I highly recommend to you, that charts new directions in the study of the post-Civil War era. She's also worked with the National Park Service on several projects related to the era of Reconstruction. In 2014-15, she was an Andrews Fellow at the Hutchins Center for African and African American Research at Harvard University. And finally, last but not least, Thavolia Glimpf is a professor of history and African American Studies at Duke University. Her research and teaching focuses on slavery, the U.S. South, emancipation, Reconstruction, and African American women's history. She's the author of a wonderful volume, Out of the House of Bondage, The Transformation of the Plantation Household, published in 2008, and is a co-editor of 2 volumes of Freedom, a documentary history of emancipation, 1861 to 1867, a part of the Freedmen and Southern Society Project. Her forthcoming works include Women at War, Black Women and Children Refugees, A History of War and Refugee Camps in the United States, which is a study of the experience of enslaved and freed women and children refugees on the battlefields of the Civil War, and a study of Civil War veterans who served in the Egyptian army in the 1870s, entitled Playing Dixie in Egypt. As I'm sure you can hear, this is an extraordinary panel for this discussion. Please join me in welcoming them. So I have to tell you that I am fascinated and really riveted by the period that we call Reconstruction, and I could not imagine 3 better people to have this conversation with. And so I have my own curiosities, and so you're basically just listening in on my conversation with these 3 individuals. I really want to begin with the term Reconstruction, because people use that word, and I'm not clear that everybody knows exactly what it means, what time period we're talking about, how we really border Reconstruction in its beginning and its end, and how we separate it from other periods during that time. And I think I want to begin on the far end with Kate, because Kate has suggested that maybe the very term Reconstruction is one that we should retire, and that maybe we should more be talking about the post-war period. And so I just thought since that's so provocative, because so many of us are so connected to this term Reconstruction, if you could kind of describe why you posit that theory and what you mean when you talk about this period, and then we'll take it to Thavolia and to Eric.
Sure, thank you. So in the volume that I co-edited with Greg Downs called The World the Civil War Made, in our introduction to the volume, we talked about how the complexities of the use of the term Reconstruction. And first of all, the chronological parameters of Reconstruction, let's say, for example, in Eric Foner's fabulous work of synthesis and pioneering scholarship, defines the period from 1863, the issuing of the Emancipation Proclamation, to 1877, which was the compromise over the election of 1876. That's a more or less traditional, well, especially now that several years since the publication of Eric's book, that's how people often talk about it. Sometimes they start with 1865 to 1877. And so this is a period after the Civil War. It is a period of tremendously creative policymaking, as we talked about in the first panel. And so sometimes when people talk about Reconstruction, what they mean is the policies that were made primarily in Congress to reconstruct the nation, to bring the former Confederate states back into the nation, to make a new nation. So that's a kind of version of what is Reconstruction. Another kind of broader way of using the term is it's a period in American history. It's a period in which a huge number of things were going on simultaneously, and it's not just about policymaking from Washington, it's about grassroots politics, it's about kind of every kind of debate about what kind of a country will exist post-Civil War. More recently, some scholars and other people have talked about other versions of Reconstruction. Reconstructing the North, what did that look like? Reconstruction of the West, the idea of a greater Reconstruction that ran from the end of the Mexican-American War into sometime in the post-Civil War period. And so there's this kind of proliferation of ways of talking about Reconstruction. And so one of the ideas that we were playing with there was, in order to really define what we're talking about, what would it be like to bracket the term Reconstruction and just try to talk about precisely what we're talking about? Some people may be writing about policy. Some people may be writing about the meanings of freedoms for African Americans. Some people may be writing about Indian wars in the West. And instead of constantly reconstructing this or reconstructing that, maybe it would be useful to kind of go back to basics. So I just want to say I'm not polemical on this issue, and I'm sure we'll use that term a lot in this panel, and that's completely fine with me. But I think it's an interesting thought experiment and a way of just trying to clarify what we're talking about in general here.
Well, it is, and the reason I wanted to begin with that question is because, Zivolia, to reconstruct something implies that you are constructing something that was already constructed before and then destroyed. But the truth is, an America in which black people were actually citizens and so forth actually had not existed before. And so we weren't actually reconstructing anything. We were constructing something new and fresh, potentially. And that may be part of the challenge. But how do you define the term?
I think you're exactly right, that part of the challenge is that we are really building something new. And Reconstruction does imply that we're rebuilding something, and maybe we're doing both at the same time. And I think to talk about the chronology, it's really important, I think, to think about Reconstruction as beginning when the war began. Because at that moment, Americans had to start thinking about, okay, what will come after the war? At that moment, they had to start thinking about what would happen with the slaves, because at that moment, black people began running away from slavery. At that moment, the nation had to figure out what was the relationship between the northern states of the United States of America and the southern states. So when Lincoln goes before, the country and he gives his first inaugural address, he's really trying to parse this moment and what it will mean, what war means and what Reconstruction will look like. And he doesn't do a very good job as far as black people are concerned, but he is trying to deal with the bigger question. And so I think Reconstruction begins in December of 1860, when South Carolina secedes from the nation. Wow. I'm not sure when it ends, but I'm perfectly happy bringing Reconstruction to an end with the Plessy decision. I mean, I think it sort of very clearly says, we're done with you people, that is, former slaves. We're moving on, and I think it's really important to think about what that declaration, "we're done with you," really meant, and how long it had been festering, and the ways in which it had been festering. I think the first panel dealt with that to some extent.
Terrific. So Eric, you wrote the book?
Yes.
You put the dates out there?
Well, I have a vested interest in keeping the word Reconstruction because that's the title of my book. So I don't want Kate changing the nomenclature here. But yeah, the fact, actually, I think the way to think about Reconstruction is as not as necessarily a specific time period, but as a kind of historical process. The process by which the United States, everybody in the United States, had to try to come to terms with the consequences of the Civil War, the two most important of which were the preservation of the nation and the destruction of the institution of slavery. What are the consequences of those things for Americans, North, South, East, West, et cetera? In that sense, Reconstruction is still going on. And we're still trying to come to terms with the consequences of the end of slavery in this country. But I would just add that this was debated during Reconstruction because whether you called it Reconstruction or Restoration was a political question. Democrats tended to talk about restoration. Yes, there's a war, we're going to keep the nation together, but then we're just going back to, their phrase was the Union as it was, the Constitution as it is. They didn't, Reconstruction implied radical change in the Constitution, as we heard, and in many other aspects of life. And there were many who didn't want that to happen. So Reconstruction had I think had a more radical implication, at least in the earlier years, than one might think. But the date it ends, well, if we could go pay, historians don't know how to count, really.
Well, no.
We think, there's a long 19th century, which goes from the French Revolution to the, it's not more than 100 years. But if we're going to use a Supreme Court decision, we might even go further into maybe Giles v. Harris, which is the early 20th century, where the Supreme Court just threw up its hands and said, look, if the people of Alabama, the white people, want to disenfranchise all the blacks, we can't do anything about that. Tough
It may
luck.
be unconstitutional, but we can't change it.
We can't do anything, so forget it. Don't bother us anymore. You could say that's the end of Reconstruction as a political process, where the elimination of the black vote in the South ends the political opening that Reconstruction had created years before.
Well, I tend to think of it as the civil rights cases, and
that's another one.
Was that 1885 or 83, right? In which the Supreme Court essentially says, how long must we, treat the newly freed slave as a specially favored class? Expressing what my colleague Darren Hutchinson called racial exhaustion. For people who have that expression today, right? Who say how long, about affirmative action? They should know that the Supreme Court was saying that 20 years after slavery ended, they were saying, oh my God, haven't we done enough? And so I kind of think of that as the date. But something interesting in your book, Eric, and maybe we can talk a little bit about what the features of Reconstruction, what was this period like? What was happening, particularly politically, in the South for blacks and for whites? The part that I think is interesting is that you use this term presidential Reconstruction. Remember, this is after the assassination of President Lincoln. Andrew Johnson is the president, and he's a very particular person, and you can maybe describe him a little bit. And he makes some choices, some very timid choices. We heard in the previous panel Daryl Miller talk about the fact that there is actually a narrative and a history of what conquest looks like, but it's clear that this is not in the cards, certainly for President Andrew Johnson. And so some of the choices he makes about political leadership in the South in this period may in some ways have laid the foundation for the dooming of Reconstruction as being as transformative as it could have been. And I wondered if you could begin by talking about that.
How should I put this? Sometimes we find ourselves as Americans stuck with a president who is just totally unfit for the office. And, that was Andrew Johnson. Johnson has a good claim. Johnson has a claim to being the worst president in American history. There are contenders for that, but Johnson has a claim. One could go into a long thing, but the basic point he suggests, he was deeply racist. He had no ability to work with Congress. He had no sense of Northern public sentiment. And presidential Reconstruction, he set up new governments in the South, all white, with black people having basically no civil rights at all, and no political rights whatsoever. And, they went on and did things we heard about in the previous panel, these black codes and other forms of, of subordination of the black population. But I think one then has to go beyond that. I mean, if you mentioned Du Bois, I think the most important way to think about Reconstruction, to my mind, is the way Du Bois described it. It was a moment in the history of democracy in this country, and in fact in the whole world. It was a remarkable effort to create an interracial democracy in a society less than 10 years past slavery. And, it didn't work in some ways, it did work in other ways, but the very fact that this happened and that African Americans began exercising genuine political power was a remarkable thing in the 19th century in the aftermath of slavery, and generated a violent reaction. We heard about the Colfax massacre in the previous panel, and many, many such incidents in the South. So, politically, Reconstruction was a radical change in the nature of what had been a slave society until just a few years before Reconstruction was implemented.
Do either of you want to comment on that, on the kind of promise of Reconstruction and the thwarting of it? I mean, one was that the absence of presidential leadership, right, to make the right kinds of decisions, but there were other reasons or other contributing causes to, this moment of democracy being a moment rather than the kind of extended period that it could have been, that could have been truly, truly transformational. And that moment was fairly easily undone because of multiple reasons, not just President Johnson. So, Thavolia, why don't we start with you and then go to Kate?
Okay, so I want to go back to your comment about this racial exhaustion problem. I think Reconstruction was undone in part because we had a president who was not willing to do what was necessary. But I also think it was undone because we tend to think of Reconstruction ending after the withdrawal of troops in 1870, or the compromise in 1876, leading to the withdrawal of troops. And that this moment signifies the racial exhaustion. But I think it goes back further. I mean, I think if you look at the very moment that Black people were emancipated, the moments, going back to the Civil War, going back to the Emancipation Proclamation, going back to congressional measures like the Confiscation Acts of 1862. At each of those moments, there was resistance from white Americans, North and South. And so that resistance in some ways solidified, and I think by the time we get to Reconstruction, there is still massive white resistance. We see it in the race riots in New York. We see it in the sort of repellent actions on the part of military officials during the war. We see it after the war. We see it as African Americans are now free people trying to grab hold of, claim citizenship and give some meaning to freedom. We see them being constantly pushed back. But what's also very important to me is that we see them keep pushing forward. And that's what Du Bois was talking about, this constant effort on the part of Black people to keep that movement going forward in spite of the violence, in spite of Colfax and many more Colfaxes. And I think one of the arguments I've been trying to make for years, and since I'm putting it grammatically in that way, that means I didn't succeed, is that when we talk about monuments and memory, we are always framing Black people sort of responding to these monuments. And so my argument has been and remains that the monuments are a response to Black people's efforts to claim their freedom and citizenship. It's a response to their coming out by the thousands. You'd find Emancipation Day celebrations where there'd be 10,000 people, 5,000 people. People would come from miles, they'd walk for miles to these celebrations, not just to have a party, but to hear people talk about what it means to be free, to hear how their emancipation compared to the emancipation in other places in the world, in Haiti, for example, to hear how freedom looked here in comparison to Prussia even. And to hear people say to Black women who were constantly being attacked and sexually assaulted, fight back. And we know that if you fight back, you might end up dead, but fight back. So there's that sort of, to use a very poor choice of words, that sort of discourse that Black people are putting out there, and white people are responding by, no, we're going to keep pushing back, and they do, and ultimately we got these segregation laws in the 1890s and the disfranchisement laws beginning with Mississippi in 1890.
Well, I guess one way that I have come to want to talk about this sort of notion of Northern exhaustion, or one of the narratives, is that Northerners just got tired of these issues and they turned their attention to other matters, and there was, the problem of greenbacks, and there was the Industrial Revolution, and this sort of, it ends up feeling like what happened was the Republican Party in particular just kind of casually shifted gears. And one of the points that I want to emphasize, and this is something that we ended up writing about also in the National Park Service study, white Southerners made Northerners tired, if you will. One of the things that was happening was the perpetual white resistance to Reconstruction policy, to sort of overtly violating federal law, to not caring about federal authority, to actually shooting federal officials or harassing them, running them out of town. White Southerners created a series of kind of constitutional crises about how far under the 14th Amendment and the Civil Rights Acts, not just of 1866, but of 1870 and 71, how far could the federal government go, particularly using the Army, to continue to put down what were essentially white Southern insurrections against federal power. And that, we can talk about the inadequacies in some respects of Congress's and President Grant at that point's responses, but the kind of continuing assault on federal policy was, it created major dilemmas for these federal officials. If you had white Southerners saying, okay, we get it, we understand, this needs to be the policy now, we might not like it, but we're going to comply with it, there wouldn't have been so much exhaustion in the North, right? There would have been more kind of ability to continue to enforce these policies. So I just want to also restore some agency to white Southerners in this for helping to create that backing off of Reconstruction policy.
I want to come to you, but just because you say that, Kate, and I think it's so important, I want to actually return to what happens in the immediate aftermath of the war, because Eric says in his book that essentially right after the war, the expectation of white Southerners was it's a wrap, right? That we lost and here it comes, right? They were braced and would have, at least you, I hope I'm not, I hope I'm saying it correctly, but you implied that they would have acquiesced in large measure, not entirely, had the federal government come with the kind of strong, uncompromising positions that they expected would come. And that in fact, the timidity of the federal government allowed the Southerners to think that there was room for this kind of a pushback that you're describing and actually opened the door. So I think you're absolutely spot on to point out that agency, but I want to return to this. Am I saying correctly what your thesis
correct.
is?
Yeah, I mean, and this goes back to Andrew Johnson.
Yeah.
Basically, Andrew Johnson told the white South, you don't really have to worry about all this stuff. Yes, the slaves are free. You're not going to have slavery anymore, but other than that, you can do pretty much whatever you want. And instead of, yes, many white Southerners expected what they would have considered harsher or stronger measures from the federal government. This is all in 1865, but the other side of that story is Johnson's intransigence and the violence in the white South is in some way the creative dynamic that is pushing Congress further, Northern Republicans. You wouldn't have had a 14th Amendment in exactly the form it did without Johnson's intransigence and the violence in the South. You wouldn't have had a 15th Amendment later on. You wouldn't have had radical Reconstruction. So it's pushing Congress. The very conflict is pushing people in a more radical direction until eventually they don't go any further in a radical direction for some of the reasons Kate was suggesting. The main point, I guess, really, I mean, you're absolutely right, is that this is a dynamic period. It's a period in which people's outlooks are changing all the time. People who in 1865 said, "No, I can't imagine we could give black men the right to vote," 2 years later are voting to give black men the right to vote. People who said, well, we can't really deal with private discrimination, then they go and vote a few years later for a bill banning discrimination by hotels and railroads and things like that. So you can't freeze this process at any moment, and you can't freeze people's ideas. One of the problems with trying to figure out, let's say, well, what was the intent at that time? Well, the intent keeps changing all through the period as events, take unexpected courses. So you have to look at the period whole. You can't say 1865, 1867, 1873. It's a long, complicated, dynamic process.
Thurgood, I want to go back to this issue of what African Americans are doing in this period. Because this is also, just to me, a very, very powerful story, because African Americans are living in these communities with the kind of violent pushback that you're talking about. They're still showing up to vote. They're still trying to be postmasters. They're still being Secretary of States. They're still trying to be magistrates. They're still being the police force. They're still pushing and pushing and pushing and pushing to have this full citizenship, despite this the threat of how they're living. And so I want to talk a little bit about that political push. I also want to talk about the economic piece and what's happening during this period, right? So now we're in this post-war period. What happens to Black people in terms of their economic possibilities? What happens to the 40 acres and a mule? What's the situation in terms of land? And given what we know about the Black codes, which I think Daryl Miller described as supporting a kind of cartel for Black exploitation, which I think is a perfect way to describe it, how are Black people managing their way through this kind of economic stronghold that really is in every form seeking to return them to slavery in some form or another? So I'll start with you, Thurgood.
Okay, so I really appreciate you getting to the economic question. I want to start there because when we consider that when the war ended, the South was broke, right? Emancipation had liquidated the bulk of its wealth by emancipating enslaved people. So the war ends. It's April 1865. It's the time of the year when normally you would be beginning to plant your cotton crop. And who's going to plant it? How are you going to convince former slaves to go back into the fields, and at what cost? Can you pay them? So it's not only that you have 4 million ex-slaves, you have hundreds of thousands of ex-masters, right? Who may still now have land if it hasn't been confiscated, and Johnson will soon give it back to them. But that they don't have any money. The sources of their wealth, as I said, it's been liquidated. The paths to getting more money from banks is no longer possible. So all they can do is go to Black people and say, look, we've got land, you've got your labor power, let's make a deal. And the deal that gets made is often confused with what comes later. The deal that gets made is what we call share wages. I can't pay you except in a share of the crop. You work, when the crop comes in, I'll sell the crop and I'll give you a share, a quarter, an eighth, whatever the deal is. The later thing that a lot of people talk about is sharecropping, which is a very different system. It's just a system basically of renting. And you have to put something in. If you're a Black sharecropper, you're saying to the owner of the land, look, I've got something to put in. I've got 5 kids and I can put their labor in. I can find a way to feed myself. My wife can grow some food or whatever. So it's a more of a relationship where you have more say-so. But in 1865, it's really kind of up in the air. People are trying to make deals, and in the midst of trying to make those deals, you get, as Daryl referred to earlier, these codes where Mississippi says, well, Black people, you can't own any land outside of an incorporated area. Well, what the crap? That means that you can't own farmland, right? So we're not going to let you be farmers, even if you want to. But at the same time, you have people who do find ways to grab hold of a few acres. In the South Carolina Low Country, my part of the world, I was born and raised in South Carolina, people are fighting to hold on to the Sherman lands. They're fighting to hold on to lands that they claimed that they bought from the Treasury Department. So it's a very dynamic situation. And in some places, people do buy land. And so in the 20th century, we have a number of Black landowners. And when you think about the recent suits against the Agricultural Department by Black farmers, those suits have a history, right? Going back to the post-war era. So in terms of working, and Black people did not have much choice. Black women, for the most part, were accused of wanting to become like white women and going into the house and not working at all, when in fact they were working in the fields and working in white homes at the same time. But they had decided that if they worked for white women, they would no longer do so in white homes if they could help it. So they would go and say, look, you want me to do your laundry? Give it to me. I'll take it to my house and wash it. I'll come and clean your house from this hour to that hour, but I won't stay overnight. So these are the kinds of sort of ordinary Martha. Where's Martha? Martha referred earlier this morning to thinking about the importance of looking at ordinary people and ordinary lives. And when we do that and we get beyond the high politics, which are crucially important to how people will live their lives, but we also have to get down and look at how they actually do live their lives.
Terrific. Kate?
Add to that, on the economic.
What was the question?
Oh my goodness, well, let's take it all the way back. So no, I was asking about, there's a political piece, but then there's also a kind of economic piece and what's happening during this period. And we know we've got the black codes, then we have this very powerful discussion by Thavolia about the agency people are taking to kind of try and make their way. And I guess what I was getting at with the question is there are these dual tracks where African Americans are interested in obtaining political power, but also very deeply on a day-to-day basis interested in this question of work and labor and the ability to take care of themselves. And that's a key issue in the Reconstruction period as well. At the same time, whites are in the South are seeking to keep blacks from political power, but also very primarily interested in how do we control this labor force for our own ends.
Yeah. I mean, absolutely. And I think sometimes when I think about teaching this material and to undergraduates in particular, and sometimes people forget about the fact that slavery itself was a labor system, right? And so the entire system that was being upended at this point was founded in how planters, people with land, were going to make money off their land growing certain kinds of staple crops. And plantations had particular kinds of forms. They required particular kinds of labor that over the course of the earlier parts of American history, ultimately people who owned a lot of land in the South began to increasingly and over time, almost in a majority used enslaved workers to work that land. And so the magnitude of the upheaval when you think about emancipation, I mean, as Thavolia said, first of all, just to imagine the liquidation of that amount of capital that people had tied up, that owners had tied up in their enslaved workers who were also used as capital. They were used as collateral for loans. They would be mortgaged. So this was enslaved people. The property in persons was a major engine of the Southern economy that kind of upheld a system of credit and debt that made everything work. And so you have the sort of liquidation of this form of property from the perspective of the slave owners, and then you have people who are becoming free who are saying, okay, we want to live, we want to survive, and we need to figure out a way to do that in the midst of this system that has, decades and decades in the making. And I think one of the things that's important also to think about is sometimes people wonder, why did freed people tend to stay where they were as opposed to just leaving? And when people are familiar increasingly with the history of the Great Migration in the kind of early 20th century, first of all, there is a lot of migration in the post-Civil War South of African Americans moving to different places, trying to find better lives, but also keeping in mind that leaving where you were required resources. There were trains, boats in the South. You could go places if you wanted, which was absolutely not true during slavery. But you had to have enough money, or if you wanted to move and become a farmer, let's say you wanted to move to Kansas or Oklahoma, you had to have tools, you had to have a farm animal. And these very kind of everyday forms of personal property were also very hard to come by in the post-emancipation South for freed people. And so the kind of economic system that's primarily rural, that is just in the kind of wake of slavery, is something that it's sometimes hard for us to wrap our minds around that, but it is very kind of important to put ourselves back and try to imagine what that would have been like.
Well, there's so many stories here that we can't really pull the thread, on. I mean, even just talking about what that movement is like. There are many newly freed slaves who are moving, and one of the reasons that they're moving is that they're looking for their family members. So there's a whole story to be told about the effort of newly freed slaves and the effort of so many of them to try to reconnect with children who were sold, with spouses who were sold, with mothers and fathers. And so there is a kind of an effort to do that dynamic movement. But as you talk about, it requires resources, it requires knowing where to go and where you are, right? If you have been raised on this one plantation for your entire life, your sense of the world and geographically is severely limited. And then, of course, the threat of violence. And we would be remiss if we didn't talk about the role of violence in the Reconstruction period, which is so important. Violence as a means of ensuring that Reconstruction does not fulfill its promise. And you talked about this already, Kate, with thinking about the pushback against the violence against federal officials. To be a postmaster was to really take your life in your hands as a black person during this period. And I think it's important to just touch briefly on the role of violence, and then I want to pivot to what's already been alluded to, and that's a little bit about what happens in reconstructing the story in the Reconstruction and post-Reconstruction period of what slavery really was, the whole lost cause idea, and the monument issue that we've been talking about, in our contemporary debates, that really emanates from what do you do when an event like this happens, when you have a massive, large-scale human rights violation happening in terms of slavery, deeply connected to the economy, deeply connected to a political system, and then it's reversed. How do you account for that in this new nation? And it seems to me this is the project that gets distorted. So maybe, Eric, we could begin with you just talking a little bit about the violence and the role of violence in Reconstruction, and then we can kind of move on to...
Well, yeah, I mean, violence was pervasive in the Reconstruction period, and as Kate pointed out, and others, it played a very important role it was political violence, or what really you should just call it terrorism, to use a current, understandable term. It was an effort to basically overthrow these governments, restore white supremacy in every area of life, not just politics, but economic life, social life, etc. And it posed a giant problem for the federal government and for local officials. In some places, on some occasions, violence was effectively suppressed. President Grant sent the troops into South Carolina in 1871 and crushed the Ku Klux Klan. But when it revived again a few years later in the Deep South, the federal government was not willing to continue the kind of exhaustion Kate mentioned because of the constant counter-revolutionary violence in the South. So yeah, you can't understand what happens in Reconstruction without also talking about the violent reaction against it, which is a sign or an indication of how radical the changes were, that those changes stimulated such a violent reaction. And of course, extra-legal violence doesn't end with the end of Reconstruction. Lynching, 3,000 or 4,000 people were lynched in the South from around 1880 to the 1950s, et cetera. So, violence remains an important part of the Jim Crow system, which comes into play after Reconstruction is over.
Given this reality, given this extreme violence to the point that you have to have actual statutes, the Ku Klux Klan, you have to actually speak to the violence, as a matter of legislation. What is the investment of Northerners in adopting a story about what the Confederacy was about that gives it some kind of nobility? Right, and we were talking about this a little bit in the corridor, right? That when we talk about the lost cause and we talk about the later period in which monuments were created and so forth, this is not just about Southerners describing the story of who they were in this war in a noble way. This is about Northerners being absolute participants and endorsers of this narrative about the nobility of the Confederacy. And yet you're describing this ongoing violence, right, that they're having to fight against, and that we could maybe say they ultimately become exhausted with, but they're not willing to do what must be done, right, to deal with that kind of terrorist violence. What's their investment in this narrative, this untrue narrative? Anybody can.
So, I think, first of all, So Kate and I kind of know we kind of disagree about this a little bit. When we say northern exhaustion, I'm talking about northern exhaustion with black people. I'm not talking about northern exhaustion with southern whites. They're not exhausted with them. So when Southerners began become even more violent, because slavery is violent in the war in itself, Northerners pushed back a little bit, with their force acts. Grant sends troops to South Carolina, but not too much. And so this is one of the really interesting kind of historical stories where a nation goes to war against people who are committing treason, right? Mm-hmm. And then it wins that war and it doesn't follow up, right? It doesn't say, okay, we won and you people are still acting crazy, so now we need to follow up and convince you that we won. Instead it says, well, there's some things you were right about. You were right that black people are inferior, right? And so we grant you that. And so then Lee, to get to the other part of your comment, your question, Robert E. Lee becomes not a heroic Confederate soldier, but a heroic American soldier. Reunion becomes not just a political reunion of North and South, but a kind of reunion that speaks to white supremacy, that puts white supremacy on a pedestal. Only this can explain why we're willing to take state and federal monies to rebury the Confederate dead, to help build monuments to the Confederate dead, to make Gettysburg not just a northern cemetery, but a national cemetery. So there are all kinds of decisions that are made in this moment that suggest, at least to me, that the pushback on the part of the North, it's there in the amendments, the 13th, 14th, it's there in the Forest Bill, but it's not sufficiently there to say that this revolution, this revolt on the part of Southern whites has to be crushed, and we have to go back. We have to go back. Instead it says, well, we'll take out the troops that we have in 1877. So I think it's really important to make that kind of distinction.
I think that's really powerful and important. I mean, I think even before, correct me if I'm wrong, but almost immediately after the war, when there were Southern jurisdictions that said, well, we just can't have black troops, and the decision to say, okay, we'll accommodate that. I mean, the accommodation begins almost immediately.
Exactly.
Yeah. Kate, did you want to?
No, I mean, I don't disagree with that. I guess one thing though, I mean, in terms of Northern white people really accepting the lost cause idea that was kind of generated in the South as a defense of the Confederacy, I think some scholarship has shown that veterans of the United States military from the Civil War held on to the idea that this war had been, sort of their version of this was a good war. We fought a bad enemy. We don't want to see a lot of concessions to, their cause was good, our cause was good, we're all brothers now. And so part of the dynamic is and this is, other historians who have looked at like the Grand Army of the Republic chapters, this Veterans Association of US Civil War veterans, is that when they died, when their generation died out too, I mean, and also let's just add that they were one group of people. They weren't necessarily in control of what Northerners were doing, what Congress was doing, but certainly when they passed from the scene by, let's say, kind of the 1890s and early 20th century, that was a really important moment for, among white people, not among black people, but among white people, a kind of the fading out of whites willing to defend what many people believed the Civil War had become, which was in part a war to abolish slavery and set the nation on a new course toward equality. And and African Americans, as we've talked about, as Sylvia has said, also continued the memory memory, as David Blight has written, continued the memory of the Civil War as being that war for emancipation, for a new nation founded on a new footing that remedied some of the problems of the original nation that was forged in slavery. That never went away. It was just that it was abandoned by white Americans for a very long time.
And you know that it's powerful because, I'm going to come to you, Eric, because of when you look at these, I'm always quite moved by looking at these monuments that were created mostly in the first half of the 20th century to a war that happened in the century before, to lift up the Confederacy. The size, the heaviness, the height, there is just in the very physicality an attempt to impose a narrative, right? To counter the narrative of reality that, as you say, never went away and the African Americans are pushing forth. And so there is a feeling, when I see them, there is a feeling of a response to, and a very powerful, an attempt to be overwhelming response to another narrative. Eric, what did you want to say about this?
Well, I was going to say what everyone here knows, that history does matter, actually, how people think about history. The mythology of Reconstruction, which I think Professor Guelzo mentioned in the first panel, that it was a period just of corruption, misgovernment, that giving the right to vote to blacks was a terrible error, was not just a historical interpretation, but it was part of the intellectual legitimation of the Jim Crow system. In other words, it had very clear lessons. It was a mistake to give black men the right to vote. Therefore, we were right to take away that right to vote, and if you give it back again, you'll have all the horrors of Reconstruction again. Reconstruction was imposed on the South by Northerners. They don't understand race relations. The horrors of Reconstruction show you that. Therefore, the white South should resist any outside pressures for change, which began to build up in the 1930s, 1940s, et cetera. And even the Supreme Court, of course, this is the problem with Supreme Court jurisprudence on this matter. It's based on history. It's based on precedent. You had bad decision after bad decision, sometimes based on a misreading of the history, but that's still good law. Very few of those cases that we heard about in the first panel have actually been overturned by the Supreme Court has never been willing to get up and say, we blew it, folks. We actually blew it, and let's start again. You can't start again. There's all that weight of history still there. And so what people think about the history of this period actually has very practical consequences, not just as an academic matter.
Yeah, and I'd say, for me, that I'll just step out of my attempt to be a very neutral moderator at this moment. But as a civil rights litigator, when you look at some of the cases that we litigate, particularly in the voter suppression space, in which not we, but federal judges are saying that whole legislatures of states like Texas and North Carolina convened and passed voter suppression laws for the purpose of discriminating against African American voters. That's two decisions by two federal courts in just the last 5 years. And you compare that to the Supreme Court's decision in the Shelby County case in 2013, in which essentially the Supreme Court is saying is, you are kind of impugning the honor and the nobility of the South, and you're branding them with this terrible history, and and it's unfair to them. It sounds in my litigation spirit very similar to what you're describing, in which the court also gets invested in a narrative about what is happening today, even when that narrative is counter to the facts, counter to what we've been able to prove at trial, counter to what federal judges have found. And so this is dangerous. Yeah. The adoption of false narratives in this space is really, really dangerous to fulfilling the promise of the 14th Amendment, which is full citizenship for African Americans. I'm going to go to questions from the audience. We have some good ones. We have multiple questions on this subject, which I think everyone wonders. Do you think Reconstruction might have gone better had Lincoln still been president, not been assassinated? Kate, I'll take it down there and we'll bring it back.
Well, I think that's a fantasy that a lot of people have, and I was recently thinking about this a lot because I was writing something about the movie Lincoln, Spielberg's Lincoln, and that there really is a fantasy in that movie. If you look closely, it doesn't hit you over the head, but there is a fantasy in that movie that if Lincoln had lived, things would have turned out better. And you have a couple of scenes where Lincoln says to Grant in this movie, don't be too hard on them, meaning the white South. And you have a scene with Thaddeus Stevens where he's kind of maniacal, whereas Lincoln is the moderate force. And so I think overall the movie has this fantasy that part of the tragedy of Lincoln's assassination was that Reconstruction would have gone better, which also sort of implies in this narrative that kind of race relations would have been better, that Lincoln would have solved all of like our collective problems with that. And I think that's, I mean, obviously not the case. I think and obviously historians also generally don't like counterfactuals, and you know, it's hard to, we can't say what would have happened, but Andrew Johnson was a totally inept president. I mean, he was not only a horrible racist, but he was also very bad as a politician. And he couldn't understand what was going on in Congress. As Eric said, he couldn't understand the kind of northern public opinion. Lincoln was obviously a very skilled politician. Lincoln might, as Eric's book on Lincoln sort of shows, Lincoln consistently over the course of his political career kind of moved to what we would consider the left when pushed by African Americans, when pushed by Republicans who were more progressive than he was. So it's possible, it's likely that Lincoln would have been a much more astute politician than Andrew Johnson, and it's quite possible that he would have worked much better with Congress, although on the other hand, he was already at odds with Congress over Reconstruction policy when he was assassinated. But I think if to the extent that the weight of the question is about whether the kind of panoply of problems and conflicts and kind of challenges of dealing with the legacies of slavery in this country could have been avoided if Lincoln had lived longer, I think, you know, no, absolutely not. This is a world that we all have to inhabit and cope with, and kind of imagining Lincoln living through his second term, it would not have solved that problem.
Eric?
I agree.
Okay. Question, should the de facto segregation of the North be part of the conversation? Yes.
Yes.
Absolutely, and I'm going to hold my comment. Anyone on the panel want to comment on that?
Of course it should, and one of the problems, and you know, or let us put it this, one of the virtues of the kind of rethinking of Reconstruction Kate mentioned a while ago is, yes, you have to bring the North into this, not only as policymakers, but in terms, the North at least acquiesced in the race system in the South, and more than that, it actually was complicitous in it. We talked about why didn't, you know, African Americans found themselves sort of at the bottom of the poorest region in the country. The South remained desperately poor all through the 19th and well into the, you know, the post-Civil War and well into the 20th century. Blacks are at the bottom of that. Why didn't they just pick up and move? You know, the real economic dynamism was in the North, the modern industrial revolution going on. Why didn't black people just pick up and go to work up there? But the fact is, those employers would not hire black people until they would much rather go 5,000 miles away to bring in people from Italy or the Russian Empire or Eastern Europe as the millions came in to work in the factories of Pittsburgh and the stockyards of Chicago, et cetera, than go 500 miles to the south and bring up blacks. How do we know that? Well, it's obvious because 1914, World War I breaks out in Europe, it cuts off immigration, then the Great Migration begins. Then jobs open up in the North at the bottom of the industrial ladder, but still much better than you can do. And then you get a massive migration of African Americans from the South to the North. But for many, many years, they're kind of trapped. They can't get out of the South, except in fairly small numbers, until jobs open up in the North. But by then, they're moving into, you know, fundamentally segregated communities in Chicago, Pittsburgh, Detroit, et cetera, and you know, so that's all part of this story of why you pick up any newspaper today and you'll discover the vast disparities that still exist in social, you know, statistics, economic statistics between black and white Americans. And it's all rooted, it's not just rooted in slavery, it's rooted in the continuation of racial inequality long after slavery was gone.
And if you really want to learn more about this, then I want to commend to you a book that was published last year. It was shortlisted, longlisted for the National Book Award, and it's Richard Rothstein's The Color of Law.
Right.
And it is about the role of the federal government in segregating the American North in the 20th century. Very, very important to marry to this period. I don't know if anyone else wants to comment on that. Yeah, did you want to say? Okay. So Eric Foner said that Reconstruction worked in some ways. In what ways did it work in the former Confederacy?
Well,
Eric, you said it.
I mean, no, oh, you go ahead.
No, you said it, so you
I
can.
don't, you know, we always talk about Reconstruction as a failure, which is, I think, not actually the best way to look at it.
Actually, we don't. Who talks about it that way?
Well, like on exam questions, midterm exams, why did Reconstruction
the
fail?
reason I'm interrupting you is because there is a narrative about Reconstruction that I can tell you is in the African American community that is actually very proud.
Good,
that
good,
really
it
that
should be.
focuses on all of the African American elected officials,
Yeah.
how many African American men were registered to vote in that period. We think that actually many Americans don't know that African Americans were, elected as
Of
secretaries
course.
of state, lieutenant governors
There's no
in southern
monuments
states
to that.
because there's no monuments.
Like
Exactly.
there are to the Confederate
Exactly.
generals.
So
no, that is, it didn't last. In
Yes.
other words, that
Yes.
is a moment
It
to
failed,
be very
right.
proud of.
Okay.
It failed to become a permanent feature of the society. But many accomplished. Apart from that, the black church as it exists today really comes out of Reconstruction. It had existed beforehand, but as a massive institution in the black community. Black families, as you said, were reconstituted who had been separated under slavery. Black schooling, black public schools, higher education comes out of Reconstruction. And these are the springboards for the future struggle. So it's not like everything was wiped away, despite the reaction that came later. And so, yeah, and even the very fact that these governments existed, that they started rebuilding the South, they set up the first public school systems in the South, they passed the first civil right. We heard about the need for state-level civil rights, as Martha said before. That comes out of Reconstruction, the first state civil rights legislation in U.S. history. So, yeah, there are many accomplishments. There are many failures, like in any historical situation.
let me use this question because we haven't used the words Freedmen's Bureau, and we've been supposed to be talking about Reconstruction, so we have to. And so I wonder if Thavolia, you or Kate could talk about what you think is maybe the most, one or two of the most positive things to come out of the Reconstruction period, some of which, still last to this day.
Well, I mean, the Freedmen's Bureau, certainly important on the ground. Important for helping people to find their families, important for helping to negotiate contracts, even though most of the sub-assistant commissioners were more inclined to say to people, look, don't expect to get rich, don't expect to eat more food, your rations will probably be the same, you're free now, and one day all that stuff will come. But still, it's important. But also, the point I also want to make here about the Bureau is that the history of the Bureau has been given to us as a kind of a burden on the American taxpayer. So this Federal Bureau is set up and has a commissioner, Oliver Howard, for whom Howard University is named. It has the state sub-commissioners and then the sub-assistant commissioners. And they're all on the ground working to help Black people make the transition from slavery to freedom. And so one thing I want to say about that is that the money for the Freedmen's Bureau in part comes from the labor of Black people during the Civil War. That what we don't talk about is that when people became free and the government sent them to work on plantations, they were paid a wage and they were taxed. And the taxes went into something called the Freedmen's Fund. The Freedmen's Fund funded the Bureau in part, and it funded several Black colleges. So that's a part of the story about Reconstruction that we don't tell, that is, if told in that way, would be seen as an accomplishment on the part of Black people, that they actually played a role in funding this organization that helped so many. And there are lots of bad stories one could tell about the Bureau as well.
What do you think was one of the accomplishments of Reconstruction that you think was long-lasting?
Well, I think I'll say what seems kind of obvious in this context, which is the 3 constitutional amendments, right? I mean, so the 13th, 14th, and 15th Amendments, which were complicated, which were not immediately realized, but which really had the potential to transform the structure of American government and the ways that we understand individual rights and equality. And you know, the earlier panel, you know, did a great job of sort of talking about that, but I think, and you said this in your introduction, I mean, I want to really, it's really important, and I hope maybe the two panels together can do this, is to contextualize the 14th Amendment in the history of Reconstruction so that, you know, it's often, we can think about it, especially if we're thinking about constitutional law or in the abstract, as just another tool or another, you know, amendment, another thing that you can sort of work through legally, but that this is a product of this era, along with the 13th and the 15th Amendments. And when you think about how they really transformed federalism, or let's say they had the potential to really transform federalism. And I like to make sure to underscore the enforcement clauses of each of those amendments. That, you know, the 5th section of the 14th Amendment is Congress has the power to enforce this amendment, and the 13th Amendment has a similar one, and so does the 15th. And that is part of what signals the transformation that before the Civil War, even if Congress, which it never did, had wanted to end slavery in the states where it already existed, or enforce the rights of African Americans or anybody else in the states, it would not have had, most people thought, the constitutional power to intervene in the states in that way. And so these amendments really transformed the role of the federal government, and they really made it possible to have an idea of individual rights that could be enforced or kind of backstopped by the federal government if the person in the local area was not having their rights respected. So it really kind of had the potential to redefine you know, just about everything that kind of goes on in this country.
So Kate has ended precisely where I wanted to end, as though planned, because I do think this is important. We knew that this panel could not take in everything. There are so many more things to talk about. We haven't talked about you know, the failure of women's suffrage, and including black women, you know, on the very terms of the 14th Amendment. We haven't talked about the effort of emancipated blacks to try and get a pension, you know, to just try and get money so that they could bury their dead, and to try and get money so that they could give old age pensions to slaves who were physically broken in many ways and who you know, could not work anymore. There are many stories to tell during this period, and so I really encourage people to delve deeply into what happened during this important period in American democracy. But Kate ended where I wanted to end, which is to say, as a civil rights litigator, that our conception of what the federal government has the power and indeed the obligation to do in the face of challenges to the terms of equal protection of laws and due process of laws comes out of those enforcement clauses of the 14th Amendment. And this innovation is how I think of it. This powerful innovation in the 14th Amendment is one of the most important things to come out of the Reconstruction period. And that is to imagine a role in which the federal government has an obligation to protect the citizens against the state. And we should really be clear about that, because I think sometimes people pretend that the 13th, 14th, and 15th Amendments are not what they are. It's powerful for an amendment to the Constitution to say no state shall, or that the state cannot, right? It is directed at the states, and provides for the federal government to have the enforcement power when the state does not comply. And as you look and you read about different challenges, civil rights challenges that you're seeing play out in our contemporary landscape, I invite you all to remember that by the explicit terms of these amendments, it was expected that the federal government would play a role in protecting the rights of citizens against infringements by the state. And this innovation is the center of our second founding, which happens after the Civil War and happens during this construction period with the passage of the Civil War amendments. And I just could not be more thrilled to have had this conversation with this terrific panel, and please thank them with me for this discussion.
Thank you.
Okay, thank you.
That was great.
All right, very good.
Let me unmic.
Okay. So Randy, have a seat. Okay. All right. All set? All right, hello and welcome. Thank you for being here at this terrific and terrifically important symposium and for making it all the way to the end. We saved the biggest and the best for last, so I'm really looking forward to the discussion. Before we dive into the topic, so the topic of this panel is 150 and beyond, debating the 14th Amendment today. And we're going to be looking at some of the more contemporary issues relating to how the amendment is interpreted by the courts today. Before we get into the discussion, I'd like to introduce our esteemed panelist. Sitting to my left is Randy Barnett. He is the Carmack Waterhouse Professor of Legal Theory at Georgetown Law and the director of the Georgetown Center for the Constitution. His books include Restoring the Lost Constitution, The Presumption of Liberty, The Structure of Liberty, Justice and the Rule of Law. And his latest book is Our Republican Constitution, Securing the Liberty and Sovereignty of We the People. Janae Nelson, next to Randy, is the Associate Director-Counsel of the NAACP LDF, and she's former director of LDF's Political Participation Group and a former NAACP LDF Fried Frank Fellow. Prior to rejoining the NAACP, she served as Associate Dean at St. John's University School of Law, where she was also a full professor of law, and her scholarship and research centers on domestic and comparative election law, race, and domestic theory. Sitting next to Janae is Garrett Epps. He is professor at the University of Baltimore Law School and a contributing writer to The Atlantic Online, and he serves as their Supreme Court correspondent. He is also a contributing editor of The American Prospect, and he's the author of Democracy Reborn, The 14th Amendment and the Fight for Equal Rights in Post-Civil War America, and the author of 2 great novels that you can find on Amazon. Next to Garrett is Kimberly West Falcon, who's professor of law and James P. Bradley Chair in Constitutional Law at Loyola Law School. She was a Skadden Fellow in the New York office of the NAACP LDF in 1996, and she went on to direct the Los Angeles office of LDF until 2005 as the Western Regional Counsel and Director. And she's the author of numerous articles on intelligence and fair and proper use of standardized tests, anti-discrimination, and constitutional law. Finally, we have Earl Maltz, who is Distinguished Professor at Rutgers Law School, the author of Rethinking Constitutional Law, Originalism, Interventionism, and the Politics of Judicial Review, and the author of Civil Rights, the Constitution, and Congress 1863 to 1865. Please join me in welcoming our panelists. All right, so I'll just start us off with a very general question, and you can feel free to respond as you like. So let's start with Randy, to my left. And so Randy, can you briefly summarize the importance of the 14th Amendment in constitutional law today? And in discussing this importance, can you tell us a little bit about whether you think, have the modern interpretations of the amendment captured its full scope and potential application? Is there more to be done, or have courts gone too far in applying the amendment? And what's the appropriate judicial role in interpreting the amendment?
Well, thanks, and thanks for having me here. It's great to be back at the Constitution Center, which is a wonderful resource for Philadelphia and the country. I think that in the last panel you heard one of the panelists, I think it was Eric Foner, say that the courts significantly messed up the 14th Amendment in immediate aftermath of its enactment, and they've never admitted their mistake. And I think that's right. So they haven't admitted their mistake. They have sort of rectified it partially by misinterpreting other provisions. So, for example, by eliminating the Privileges or Immunities Clause, they've rectified it partially by misinterpreting the Due Process Clause. And so we are getting results that tend to be consistent with the original meaning of the 14th Amendment. But I think the Supreme Court should really own up to its mistake and start enforcing the entire Section 1 of the 14th Amendment, which should include the Citizenship Clause and the Privileges or Immunities Clause as well. And if they were to do that, this 14th Amendment would apply beyond the scope of where the courts are currently taking it. For example, you have the right to pursue a lawful occupation, which was a right that the Supreme Court denied existed in the slaughterhouse cases. And I want to remind everybody that the next day after the slaughterhouse cases was decided, they decided the Bradwell versus Illinois case, which denied a woman the right to practice law in Illinois. And what they said the day after slaughterhouse is, we don't even have to get into whether this was a reasonable exercise of police power, which they did talk about in slaughterhouse, because we decided yesterday that there is no right to pursue a lawful occupation. Therefore, we don't even need to provide a reason for why women should not be allowed to practice law. The dissenters in slaughterhouse had to explain why it was reasonable, and then you had this misogynist opinion by Justice Bradley trying to justify the discrimination. But there's an example of a law, of a right, the right to pursue a lawful occupation, that if it were enforced today as a fundamental right, would, for example, say that African hair braiders don't need beautician's license or cosmetology licenses, which takes them thousands of dollars and hundreds of hours of study, sometimes more study than it takes to be an airplane pilot, just so that they can braid hair. That is a right that is not recognized by the Supreme Court. It is recognized by some states. And that's just the beginning of what we would get if we if we started enforcing the 14th Amendment according to its original meaning.
So Janae, same question to you, and feel free to comment on anything that Randy just said.
Sure. I couldn't agree more that the courts got it wrong from the beginning. The only amendment I'd make to what Randy said is that the court continues to get it wrong. That we see a number of cases in which the court has an opportunity to interpret the 14th Amendment in its full breadth and doesn't do so. And we are burdened by these decisions, by decisions like McCleskey versus Kemp, in terms of how we prove discrimination and jettisoning the importance of statistical evidence, even when it's buttressed by a history of discrimination and there's a context that makes it powerful evidence of discrimination. Washington versus Davis is another example where the court limited the scope of the 14th Amendment to focus so narrowly on intent. And we all know that to interpret such a powerful and meaningful provision of the Constitution based on a whodunit theory, can we point to someone who, or some actor who intends to discriminate, is such a limiting way of interpreting the breadth of that amendment, and particularly when we think about the Equal Protection Clause, and how we've turned that into looking almost solely at application, not really the full breadth of what it means to protect citizens on an equal basis. That project of equal citizenship is one that barely got off the ground before the court began to thwart it with the cases that Randy mentioned and that some mentioned on the earlier panels. And I guess I'll just say one more thing just to build on what Randy said about the fundamental rights that are enshrined, at least by the court, in the court's mind, in the 14th Amendment. Having that binary of fundamental rights and classifications is so under-inclusive. It leaves out many classifications that are worthy of protection, like disability, like wealth, other ways in which inequality is perpetuated. And again, the fundamental rights do not cover a right to education. They not cover really basic rights that I think we'd all think are fundamental to a healthy democracy and to citizenship. So it's woefully under-inclusive, and I hope we can explore some of the opportunities to expand its breadth.
Well, I certainly think the courts are far afield from the meaning of the 14th Amendment. And am I not on?
Now you are.
Now I'm on. Okay. And I think that the striking thing, it's not just courts, it's our culture, is that in America we have constitutionalism and we have very strong belief in the idea of a constitution, but we see the Constitution as something that was created not far from here in 1787, and with a few little outbuildings that have been added over the years. And in fact, if my view of American constitutionalism, the proper view, is that the 14th Amendment is at the center of it, that this really was the second founding, and not only that, it was the correct founding, the first one having been seriously flawed, and that a proper sense of constitutionalism would regard the framers of the 14th Amendment on a par with the people we revere for their roles in Philadelphia, and would take note of the fact that the 14th Amendment is the first time the word equal appears in the Constitution as a human concept. Prior to that, it was, states shall be equal in this way or that. And for that reason, I think that the 14th Amendment can and should be read as a whole as having a very specific content. And that content is that we are to remake this country, which was almost destroyed by one thing, which was the ability of oligarchic, slave-owning state societies in the states to exercise control over the national government. This is what was called the slave power before the Civil War. And that the 14th Amendment is there to ensure that we remain what Carl Schurz called a union of truly democratic states. That if the states are democratic, if the states allow participatory democracy, then the union will be all right. And instead, the court's constantly tiptoeing around vote suppression by the states, by felon disenfranchisement by the states, by various forms in which local elites within the states maintain oligarchical positions, and we are troubled by precisely the same issues. So I would like to see the courts, they could start by reading my book, it's all in there, but I'd like to see the courts do more with the sense of the Constitution as being formed by the 14th Amendment.
Well, first I'd like to say how appreciative I am of the opportunity to be at the National Constitution Center to think about the 150th anniversary of the 14th Amendment. I teach constitutional law on a regular basis, but to think about the 150 years with the amendment holistically is really a treat. It's a treat that when I'm done with that process, the Supreme Court is not wearing a white hat. Congress is wearing a white hat for having ratified the amendment, but sadly, much as my constitutional law class usually develops to make clear, if there's a villain in the story of what went wrong with the 14th Amendment, it's very much the Supreme Court. And you've heard from prior panels, some of that can be laid at the feet of the court interpreting the Privileges and Immunities Clause as a nullity, with which I think there is room to critique. I think there's also substantial room to critique the court's failure to interpret the Citizenship Clause in the way that Justice John Marshall Harlan advocated for in his dissents in the civil rights cases. So not 15 years after the ratification of the 14th Amendment, there was a viable interpretation of it that really fit with where the last panel left off, an interpretation that was true to Section 5 of the 14th Amendment, that Congress had some enforcement power that was substantial. And so I don't think we have to go very far past that 15-year period. Sherrilyn Ifill already made this point in the context of the civil rights cases, that the Supreme Court played a very critical role in interpreting the 14th Amendment and the Citizenship Clause in a very narrow way, and I think it made that almost a nullity. While it certainly did overturn Dred Scott, using the civil rights cases as an opportunity to strike down a civil rights act that hasn't come up so far. There's been talk of the Civil Rights Act of 1866, but the Civil Rights Act of 1875 was a basic public accommodations act, an act that would give African Americans and other people of color access to opera and theaters and to hotels. And so it's little known, at least among some of my law students, that the second Reconstruction and the Public Accommodation Statute of 1964 had a precursor that was was almost identical, that African Americans were responsible for exercising their full citizenship rights by riding rail cars, by, again, going to hotels and theaters, and that the Supreme Court of the United States struck down that law and said it was outside the scope of Congress's power under the 14th Amendment, at least from the perspective of a constitutional law professor, is to me how the Supreme Court played a very critical role in ending at least what the 14th Amendment's promise was with respect to the Constitution. So I would say, sadly, that the importance of the 14th Amendment has really been, for the vast majority of its time, and with those provisions except the Due Process Clause, I would say it's been an amendment that has operated to reinforce existing power structures, and that we see that with what we've already talked about with respect to the Privileges and Immunities Clause and the Citizenship Clause. The Due Process Clause, when I look at the 150 years, I see what maybe folks would want to see on a day of thinking about commemoration. You see a provision that while we have the Lochner era that we demonize in con law, where the wealthy and the powerful were benefiting from the Due Process Clause, there is, since 1937, a story of greater liberty coming from the Due Process Clause, with high points like Griswold versus Connecticut, Roe v. Wade, and now Obergefell versus Hodges. That's the trajectory where the Supreme Court gets to wear the white hat, and I want to give it its due with respect to the Due Process Clause. With the Equal Protection Clause, however, my look back at the 150 years, I'm fond of doing arithmetic at best and sometimes statistics at most. I'm that law professor who loves numbers. I came up with only about 19 years of the Equal Protection Clause protecting people of color and protecting the disenfranchised in a way that had a practical significance. So that leaves all the rest of the 150 years. The first 86 were years of really treating the Equal Protection Clause as dead letter after striking down the Civil Rights Act of 1875 and saying that states have the power to protect people of color from discrimination, then proceeding in Plessy versus Ferguson to say that too is consistent with the Equal Protection Clause. So that's a horrible start with 86 years. And then I think 1976 is when I see the Supreme Court ending the second Reconstruction, and much more subtly, but through cases, as Janae mentioned, Washington versus Davis, San Antonio versus Rodriguez, rejecting the fundamental right to education as a claim, rejecting protection of people on the basis of socioeconomic status. And since then, an Equal Protection Clause that has virtually almost exclusively, I have a hard time, I don't teach my con law students any cases, any modern cases that are people of color making claims under the Equal Protection Clause, sadly except Korematsu, which is Fred Korematsu challenging his internment and losing. And then after that, it is rejected white plaintiff after rejected white plaintiff challenging race-based affirmative action and being treated with the utmost deference and receiving the court's highest level of scrutiny under the Equal Protection Clause. So again, I'm very honored to be here, and it's a wonderful chance to really think about this momentous day. But again, I think it's a spotty mixed bag with the different provisions of the 14th Amendment.
I'm also honored to be here. Thank you for inviting me. I actually have a very different perspective than all of these panelists. I begin with the view that the country would be better off if there were no judicial review at all. And then that having been said, I think that given that the Congress and the people who ratified the 13th, 14th, and 15th Amendment had a legitimate authority to do that, I have to give I would give a strong deference to the decisions of other branches of government, even under those. And when I say that I think the country would be better off if there were no judicial review at all, I'm not saying that all of the decisions made striking down laws were bad, and some of them were very important. But I think that there's no reason, partially for the reasons you talked about, there's no reason to believe either in theory or in practice that in the long run that we are better off because of having judicial review. So that makes me talk about a couple of other cases, two of which you described. Now I have to think about precedent. And now I have to think about Obergefell, and I have to think about parents involved, which is perhaps the most draconian affirmative action decision the Supreme Court has handed down. I don't have a theory of precedent, a developed theory of precedent like I know Randy does. I have I'm sort of on a case-by-case basis. Just to say that my view of Obergefell would be not talking about the policy merits of the decision, that I think that Obergefell should not be overruled because it would create chaos, and there's been substantial reliance on this from people who've got married under the rule established by Obergefell. And on the other hand, I think parents involved should be overruled just because I don't see any reason why it shouldn't be overruled. That nobody has relied upon it, and I think it's just a bad idea. And just to reinforce the last point about judicial review, I want to point about cases that not only the last panel but this panel has talked about. I want to talk about not only parents involved, I want to think about Cruikshank, think about the civil rights cases, and most recently think about Shelby County, the case which essentially got rid of the preclearance requirement of the Voting Rights Act. So that's all I got to say.
Okay.
Not controversial.
Great. Well, there's a number of topics on the table, and so maybe I'll just pick up with Earl where you left off. And so, Randy, do you have anything to add to what Earl said about judicial review, maybe the court's approach to interpreting the amendment, but then also relating to what Janae said about the under-inclusiveness of the equal protection jurisprudence? Do you think that Justice Kennedy was sort of on the right track in Obergefell, or what do you make of the rigid classification that the court has used up until this point? Yeah.
Well, I strongly disagree with my friend Earl about the value of judicial review. Although, in fact, at the founding, it wasn't called judicial review. The term judicial review is a 20th century term. Unknown before the 20th century. It was considered to be, as Philip Hamburger has shown in his book, a judicial duty to follow the law. And in this case, if a higher law is in conflict with a subordinate law, then you follow the higher law. The higher law is the Constitution. The lower law is a statute. If there's a conflict between the two, as Alexander Hamilton explained in Federalist 78, you follow, and I guess there's an exhibit to Hamilton here now, so I can invoke Hamilton here in these sanctified quarters. You follow the higher law, which is the Constitution. The judges have a duty to do that. And I think it's salutary when they do. Most of the failures, Earl has come up with a couple of counterexamples, but most of the failures of the court have been in the failure. It's failure to invalidate laws, not its invalidation of laws. Although I do agree the invalidation of the Civil Rights Act of 1875 was horrible, an egregious act by the court. Most of the examples of judicial failure are a judicial failure to enforce the Constitution against either the states or the federal government. So on that, I part company. I don't necessarily think that the scope of judicial review is as great as others may do. I think there's room for disagreement amongst the branches about. I don't think the Supreme Court is the ultimate determiner of what the meaning of the Constitution is. It is the ultimate decider in a particular case, that's for sure, but not in the long run. The Dred Scott case tells us that. Just because the Supreme Court says it's so doesn't make it so, and that gets us back to the issue of precedent. I don't necessarily have a fancy theory of precedent. I just don't think the opinions of judges trump the Constitution. And particularly isn't true for long dead justices. They don't trump the Constitution either. And if there's a clear conflict between what the Constitution stipulates and what the Supreme Court has said, then the Constitution must govern over the Supreme Court just as it does over a statute. But last thing I'll say is that every officer, everybody who takes an oath has a duty to enforce the Constitution. Congress should not pass a law it believes to be unconstitutional, regardless of whether it'll be upheld by the Supreme Court. The President should not sign a law that he believes or she believes is unconstitutional, regardless of whether it will be upheld by the court. And finally, then, only if those two bodies say, okay, we're going to pass the law, we're going to sign the law, we're going to override the veto, only then does the court get a say as the third branch of government, and all three branches ought to agree that a measure is constitutional before we should consider it constitutional.
So I'm reminded of something that Thurgood Marshall said, who's the founder of the Legal Defense Fund, about the role of the judiciary in interpreting the Constitution, and that is the judiciary is there to protect those who other institutions leave unprotected. We haven't seen that, and you point out, Earl pointed out a number of decisions that are problematic, and we've all expressed our concerns, Shelby County being one of them. But I don't think we can pick and choose when we want judicial review and when we don't. The courts have played an instrumental role in shaping the 14th Amendment in problematic ways, but also in animating certain principles. So I do want to be clear that this is not, a complete and total disaster. I think we see ways in which the court has responded, not as forcefully as we would like, but obviously Brown versus Board of Education, the court advanced an equality principle in this country that left to its own devices, it never would have come to, certainly not at that period of time. And even though it did not do it as forcefully and as fully and as full-throated a way as we would have liked, the court played an instrumental role in changing norms and principles and really sussing out that doctrine to some extent. The court just hasn't gone far enough, and it has made many missteps and taken us in directions that that really haven't been loyal to, I think, the spirit of the Constitution, or the spirit of the 14th Amendment in particular. But judicial review, and particularly I want to focus on this idea of judicial activism, because that's a term that gets thrown back and forth depending on how you view yourself ideologically. Judicial review is problematic when there is judicial activism in the true sense of the word, where the court is reaching beyond, and this is, I guess, to some extent what Randy is saying, beyond its authority and interpreting the Constitution in ways that are not justified by either the letter or the spirit of the document. And that has happened in a great many ways, and I think we can talk about some of the more problematic cases where that's manifested. But judicial review should not be something that we can talk about the limits of it and the scope of it, but it's something that has been a protective force in many ways, and something that I think we should speak to with some respect.
I smile because I have an article coming out called The Letter and the Spirit, which is a theory of interpretation and construction. It's coming out in the Georgetown Law Journal, so that made me happy.
You can cite me.
Well, I guess my take is that I really don't think whether we should have judicial review or not is a genuine normative question in front of the House. It's the system as we have it today wouldn't operate without a robust system of judicial review, and we can debate about whether any individual instance of it was warranted or not. But I want to speak up for one of the neglected sections of the 14th Amendment that I think doesn't get the attention it deserves, and that's Section 5, in which the framers explicitly empowered Congress. There's not a word in the 14th Amendment about the courts, and in fact there's every reason to believe the framers really didn't trust the courts, whose most recent product had been Dred Scott. And if you look at Congress's performance over the years as an enforcer of the 14th Amendment, it's got some really good points to its credit, beginning with the Civil Rights Act of 1875, coming forward to the Civil Rights Act of 1964, the Voting Rights Act in 1965, the Violence Against Women Act, and what we see the court doing over and over is stepping in to sort of say, no, this 14th Amendment nonsense mustn't be carried too far, because really, this is really matters for the states. So, if you had to choose one or the other, you might choose Congress. But whether or not, I think people thinking in terms of the 14th Amendment's importance in our system need to recognize that a robust role for Congress in considering and debating the protection of rights was really very much part of the text and the structure and the debates, and we are shortchanging that ever so slightly because the court has stepped in so readily in order to decide what the 14th Amendment means?
I'm going to situate myself as, I guess, a traditionalist compared to the claim of eliminating judicial review and being on a panel with, I think, at least two originalists. I'm not going to miss the opportunity to engage on that front. So the traditionalist in me would say that the argument in favor of judicial review is just the basic separation of powers need to have a check on the other branches of government, and that the whole point of the exercise is we can't allow tyranny from any of those branches. So that leaves me with a court that I have said is wearing a black hat for most of the time. And if I'm not willing, or at least not yet persuaded, that originalism should unearth or unseat the court's current common law precedent-based approach, the court's assertion that it abides by principles of stare decisis, then I have no choice but to ask that the court abide by that consistently. And so that's a very traditional critique, but one that I think is of value in light of what I'm saying about the trajectory of the 14th Amendment. Again, I think over time, and I think we are at a high watermark for the Due Process Clause. I think that's, again, what the court's striking down of same-sex marriage laws means. It's arguably a high watermark for power for the court. I'd concede that there's a lot of discretion that the Supreme Court now has in interpreting what's protected under the Due Process Clause. But specifically with respect to the Equal Protection Clause, what I would present as a notion of how a traditionalist could still reach the conclusions I reach is that the slaughterhouse cases, which have been invoked in the context of talking about the Privileges and Immunities Clause, are also extremely important for a first interpretation of the Equal Protection Clause, and one that is consistent with using the specific intent of the framers of the 14th Amendment as a source of constitutional interpretation, but then I don't have to next become an originalist to just say we can still use a common law precedent-based approach and still have some interest in what the framers of that amendment meant, but also that first interpretation in the slaughterhouse cases. And I actually, so I wouldn't, what the court said in the slaughterhouse cases, among saying that people who had been enslaved should be free, it said the protection of the newly freedman and citizen from the oppressions of those who had formerly exercised unlimited dominion over them. That interpretation seems absolutely positively solid, and it's the earliest and first interpretation of the meaning of the 14th Amendment. What is tragically wrong is that the court rejected that not too long after, in 1883, when it struck down the Civil Rights Act of 1875. So all we need to correct the court's interpretation of the Protection Clause is for it to return to its earliest interpretation, and not to say that we couldn't and continue to have a broad interpretation of equal protection that protects women, protects sexual orientation minorities, and gender identity minorities. But what is truly perverse is that there is binding precedent where the Supreme Court first interpreted the Equal Protection Clause again to protect people of African descent from the oppressions of those who had formerly exercised unlimited dominion over them. And that's not what we see in the current Supreme Court at all. That instead you have a Supreme Court that, starting with those 1970s cases, has said that the idea of protecting discrete and insular minorities is not our business anymore. Justice Scalia said that in a concurring opinion in Schuette, that he looks at Caroline Product's famous footnote 4 as dictum that he can really dismiss. And so what I think is tragic is that even within its traditional framework, the court has a very easy and direct approach to interpreting the Constitution and the 14th Amendment, the Equal Protection Clause, in a particular way that would be very common sense and that would be consistent with its own first interpretation that I frankly think it is opting not to adopt because the court is not applying its own doctrine, it's not being consistent in its own theory, and I think it's letting its own ideological positions on these issues of modern importance really seep into how they're interpreting the Equal Protection Clause in particular.
30 seconds. If I could be sure that the 9 justices on the court would somehow be sympathetic to my ideological perspectives, I would be all in favor of judicial review. However, I want to talk about 2 things. First, we have what our current system is, which is whatever 4 smart justices and Justice Kennedy agree is what the law is what the law is. And second, if for my progressive friends in the panel and out there in the audience, I would suggest that you root very hard that for Democrats to get to 51 in the Senate, because otherwise, in the words of George R.R. Martin, who was my classmate, winter is coming. Because if there are 3 more years of Republican dominance in the White House and in the Senate, it's very unlikely that there's not going to be, particularly in view of I mean, there's a long rap about what's happened to the judicial selection as well, but particularly in view of what judicial selection is, it's not going to matter what 400 members of the House of Representatives think. So that's why I'm just not in favor of judicial review, generally. And at the very least, as I say, as an originalist, I have to believe in that original meaning matters and should be enforced, but there's a question of presumption, and I would have strong presumption in favor of constitutionality. That's all I have to say.
Okay. So we have an audience question that asks, what role, if any, does the 14th Amendment play in issues of economic inequality going forward? So maybe Janae, I'll pose that to you first.
What role does it currently play?
Could it play, I guess.
What role could it play? I think it could play an incredibly robust role if we considered wealth and class as one of the protected classes, or at least factored that into the analysis. We had an opportunity, and in fact the court did that in the Harper case when it overruled laws that required people to pay poll taxes in order to vote. We recognized that the intersection, that class 1 was a factor and wealth was a factor. Of course, it was against the backdrop of an intersection with race as well. The court had an opportunity there to continue to develop the 14th Amendment in that vein, but did not, and has repeatedly looked askance at claims that assert inequality based on wealth. I think it's going to be increasingly hard to elide that question when we have such an enormous gap in wealth and enormous issues around income inequality, a lot of them centered on race and gender. And the court could do a lot to expand its theory of what it means to have equal opportunity and equal citizenship in a society, what it means not to be bound by the circumstances in which you are born, what it means to have equal access and promise to everything that this country offers. I think the court can safely and soundly within the actual text for those who want to limit interpretation strictly to the text, even within the interpretation of equal protection under the law, and looking at due process issues and on the face of the 14th Amendment, we can support an expansion to include wealth and class.
Garrett, do you want to?
I just say real quickly that if you try to be a 14th Amendment originalist and really take seriously the thought of the people who put the 14th Amendment together, then class issues become actually quite present. Because one of the, Thaddeus Stevens, the framer, the sort of chief sponsor, says in his final remarks, you know, that the old Constitution gave to moneyed wealth the power to tyrannize over labor. And William P. Fessenden, the Senate sponsor, said his objection to slavery was that it created privileges of an oligarchical character, that they were very concerned with the disparity of wealth. That doesn't produce a determinate result for any case, but it does mean that when the court says, well, you know, the 14th Amendment has nothing to do with whether rich school districts and poor school districts should be equalized, that's wrong. That is flat wrong as a matter of history, and I think needs to be looked at very closely.
Can I switch to my originalist hat for a minute?
Sure.
Switching to my originalist hat, there was a conscious decision to change the wording of the equal protection part of the 14th Amendment from equal protection of life, liberty, and property to equal protection of the laws. Protection of the laws was a discrete right that narrowly about the protection, as some people in the earlier panel talked about, protection of people from violence and having to do with not having unequal sentences, apparently, from what I read. But there is no indication that the equal, as I said, it was deliberately made to narrow the scope of the Equal Protection Clause. That's the only possible interpretation from that, because the earlier version drew a lot of Republican dissent from it. So I know Garrett has read the legislative history of the 14th Amendment closely, but as I read it, I don't see anything in the legislative history that suggests that it was designed or thought or understood or originally meant or original methods to have the kind of equal educational funding that he describes.
Randy, and then yeah.
I'm not sure, I know I don't agree with Jared about the policies that he's talking about, or whether they're constitutionally mandated policies, but I have to add that even if you give the Equal Protection Clause that narrow and original meaning, which I think is plausible, it's quite plausible, that it's about the affirmative duty to protect, which is something that the Supreme Court has also said is not enforceable, that the government has a duty of protection. And that's all it was about, primarily enforcing the law equally. The other provisions of the 14th Amendment had non-discrimination aspects to them. The Privileges or Immunities Clause, you could violate the Privilege or Immunities Clause by denying everybody a privilege or immunity of citizenship, or by denying some people a privilege or immunity of citizenship that other people enjoy. That's a non-discrimination clause. The Due Process of Law Clause, which ought to be called the Due Process of Law Clause, not the Due Process Clause, because it requires not only a judicial process, which is really what due process is about, but also that nobody can be deprived of life, liberty, or property except by law, by a valid law. What makes a law valid or not, this is something that would take more time than we have, and I have a different article coming out about that, about no arbitrary laws. But it is not a valid law if it treats citizens arbitrarily, as I think the law in Illinois did with respect to women practicing law. So that would violate the due process of law if, in fact, someone is being arbitrarily deprived of life, liberty, or property by a statute, or what John Marshall referred to as an act, which is not necessarily a law unless it is something of unless it's an equal or general law. So there is, therefore, even under the narrow reading of the Equal Protection Clause, a non-discrimination aspect to the first two clauses that has been underappreciated. And again, this is another example of how by taking the Privilege or Immunities Clause out of the text, you then have led courts to expand the Due Process Clause to occupy some of that space, perhaps beyond where it should have gone, and expand the Equal Protection Clause beyond its proper original space to make up for the loss of a provision that if you came down from Mars and somebody said, you know, in that Constitution, it says no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. If you came down from Mars, you'd say, that sounds like a very important thing. That sounds like a very important part of your Constitution there. And then you'd have to explain to them, yeah, but in 1873, and then in the Cruikshank case right after that, the court pretty much said, we're not going to listen to that one. We're going to take that one out of the Constitution. That was a pretty big mistake.
So I say something very similar to that to my students about if you came down from Mars and looked at the Privileges and Immunities Clause, but I'm going to stick to my position as the traditional list on the panel with respect, or one of many maybe, and maybe that's to say the one point I think we have to acknowledge, and it is that while originalism is a darling of the professorate, right, we've heard that term used, that where we are right now as a matter of law is that the court doesn't do that. That is not how the court says we interpret the Constitution. So while it's very persuasive, I think, in a theoretical context to say, well, this is what the original meaning was, or this is what history tells us about that provision, the way the court, as currently constituted, says we understand the law is what a five-court majority has interpreted the law to mean, and what binding precedent is. Now, I'll put a footnote on a footnote because I'm in the professorate myself, which is to say, sure, the composition of the court may change. And if there are 5 justices who adopt an originalist approach to interpreting the Constitution, which may very well happen in even my lifetime, law as we know it, constitutional law as we know it, will change tremendously. So that's the overarching background. But as a court that develops its law and its precedent through common law, through common law adjudication, through precedent, there is nothing limiting the court to its current interpretation. And so I would echo Janae's point and just point to there are numerous cases that if the court had decided San Antonio versus Rodriguez in favor of the plaintiffs and had held that socioeconomic status was also a way a law could classify that would trigger heightened scrutiny, we could tell a very coherent and cogent story in our constitutional law classes. It would be one that would read much like, and I tell my students, it could read much like the road to Brown versus Board and the road to heightened scrutiny for gender, that there are cases like Zablocki versus Redhill and a number of cases that were filed by civil rights impact lawyers, some of whom worked at the LDF, that were trying to get that exact outcome. So for whomever asked the question, it's absolutely not a foregone conclusion that we've ended where we have with respect to the court's interpretation. And that may very well be the point, and many of the originalists would critique the court's approach for that reason, that it gives them lots of discretion. But I would say as the law is currently constituted with the current membership, and I realize it is one that is contingent on Justice Kennedy at this point, that there's nothing that would stop the court from including protection on the basis of socioeconomic status. Now, will it, which is what Janae was tempted to answer, I'm really never the one to use a crystal ball, except when I'm as certain as I am. I mean, I don't see that happening very, very, very soon, but I definitely think it could be under the court's current interpretation.
Can I add a footnote to just something Kimberly just said? Because Kimberly used a reference called, she said, the darling of the professoriate. I just want to tell everybody where that comes from. That comes from a question or a caustic remark made by Justice Scalia in the McDonald case, which was the right to keep and bear arms case as to whether the 14th Amendment would protect an individual right to keep and bear arms. And Allen Guelzo, Georgetown law graduate, was arguing on behalf of Mr. McDonald that the right to keep and bear arms really should be protected by the Privileges or Immunities Clause because that actually is one of the core rights that we know expressly was meant to be protected by the Privileges or Immunities Clause. In fact, we have more evidence on that than almost any other right, because the Republicans were very concerned that African Americans would be able to protect themselves from mob violence and also from militia violence. When Allen was making that argument about the Privileges or Immunities Clause, Justice Scalia said, well, we know that's the darling of the professoriate, or what he said is, are you bucking for a job on a law school faculty by making this argument? Which I actually thought, and I admired Justice Scalia a lot, and I certainly admired his tenacity when he defended originalism, but I thought this was actually a pretty shocking statement coming from him, because he was ultimately disparaging, not just criticizing, but disparaging the reliance on the original meaning of the text of the Constitution. And then, in defense of a traditionalist approach, which said, look, can't we get there by means of our existing doctrine, like the Due Process Clause doctrine. And I think the reason why he would prefer to get there that way is because it was a lot less threatening to other things. And so it was safer for him to stick with due process. And that's ultimately what 4 justices in the plurality opinion did in McDonald. They expanded the Due Process Clause to protect the right and keep him bear arms. Only Justice Thomas was prepared and remains prepared to revive the Privileges or Immunities Clause as a source of rights, and he wrote a separate concurring in the judgment opinion, which is the swing vote in that case. It was a Privileges or Immunities Clause opinion was the swing vote in that case.
So a note on a note, which is why I tell my students that Justice Scalia would be much more inclined to follow stare decisis, to follow precedent, and he's actually the source of that would support my point that while we can talk about originalism theoretically now, as of this particular moment, it's not the court's majority approach to interpreting the Constitution.
Can I say something really quick about originalism that I think is really important? There is a difference between originalism as a field of study that you believe illuminates the correct results of cases and should be considered by courts and lawyers, and originalism as a claim for a judicial method that this will produce determinate results. In my judgment, the latter claim, that a judge can sit down and say, and this is Justice Thomas's claim in a lot of areas, I can sit down and decide this case by looking up the original intent or the original public meaning, as he would say. That claim is incoherent. That's simply indefensible. But to say that serious research and serious scholarship and the darlings of the professoriate can produce illuminating information that is important to judges as they proceed in their common law judging, I think that's quite powerfully true, and I'm delighted to be a kind of heretical member of that particular movement.
Great. Well, unfortunately, we're already out of time for this panel, but I was going to close with just a general question, so you can feel free to jump in and add on to anything you've already said. But so we've talked a lot about where the court's gone wrong and some areas where the court's gone right. And so where do you see, what do you see the future of the 14th Amendment jurisprudence looking like? What areas of law do you hope that the court may revisit in the future? And what areas do you think that hold maybe perhaps promise or that you hope to see fleshed out a little bit more? Maybe Randy, starting with you.
All right, well, there's lots, but we have limited time. So let me just start where I started when I was mentioning the fact that the 14th Amendment protected the right to pursue a lawful occupation. In general, I think the 14th Amendment does protect what's come to be called economic liberty, as distinct from personal liberty. I think it protects both personal and economic liberty as well. And I would like to see it move in that direction. And the way I would like to see it do that is by essentially making rationality review a real thing again. It was prior to Williamson v. Lee Optical, a case that was decided by the court in 1955. Even in the Caroline Products case, which is a very famous case, the court in the body of that case said that, in fact, litigants ought to be able to challenge the rationality of laws as applied to them. Why? To prevent the enforcement of arbitrary laws. If you were to have that sort of review, not necessarily to supplant even more heightened scrutiny, I'm not saying it has to be the only form of review, but if you were to have that sort of heightened review of restrictions on individual liberty, regardless of whether they're economic or personal, a lot more people are going to get protected. A lot more people who are in the out groups and can't get legislation passed on their own behalf are going to have a shot at being protected than they are under the current conceivable basis review, where all the government has to do is come up with an imaginary justification for its rule, unless it's violating a fundamental right, when the set of fundamental rights is very narrowly defined. So that's what I would like to see the court do. It's somewhat of a modest proposal. It would, I think, have pretty substantial implications.
Anyone else? Jeanette?
Yeah, I would very much like to see the court revisit the way in which we prove racial discrimination and the elimination of the notion that disparate impact under the 14th Amendment is not viable. I think we see the progress and the remedies that are achievable in the statutory context And if there's a true pursuit of equality, of equal protection under laws, we have to have a more expansive view of how we prove racial discrimination. And even in terms of proving intent, we hear the notion of implicit bias being floated around, you know, in almost every context now. We can't lose sight of the fact that there is still explicit bias, but to expand our notions of how we get to the end result of vast inequality, we need to consider both implicit and explicit bias and consider the contextual evidence of that. And the court, as I said, has a wonderful record of ways in which to do that under the Voting Rights Act and in Title VII and other statutory contexts, the Fair Housing Act that we're also celebrating this year, and it needs to reinvigorate that analysis under the 14th Amendment specifically.
I'd like to see the court take seriously what I think the overall meaning of the 14th Amendment is, and it is this. This country cannot be healthy. This country cannot survive and thrive unless we are a union of truly democratic states, which means that politics and society in the states needs to be open. There can't be partisan gerrymandering, racial vote suppression, felon disfranchisement, constrictions on free expression in the states, and somehow produce a healthy country. That's what went wrong with the Civil War, I think the framers thought. And I think it is very wrong in a lot of parts of this country now.
I'd like to see the court revisit the civil rights cases and to, as I said, make Justice Harlan's dissenting interpretation of the citizenship clause the majority opinion, and also revisit its limitation on Congress's power to enforce Section 1 of the 14th Amendment. I think across the board that would be a move that would force the court to then have some coherent theoretical framework for what it views to be equal protection. So I think the auxiliary benefit of that would ultimately be the court and the originalist, even amongst those on the court, having to face the original meaning, the original intent, all of those things of the citizenship clause as well as the equal protection clause, because I think we are down an Alice in Wonderland sort of reality or lack of reality with how the court is currently interpreting the equal protection clause. And if we're going to have a majority of the court that rejects the idea of protecting discrete and insular minorities, a majority of the court that seems interested in protecting religious majorities, racial majorities, sexual orientation majorities, then I think the Supreme Court owes us some coherent theoretical foundation for that kind of jurisprudence.
I have just two quick things. I agree 100% about Section 5. I think that fits in with my vision. But something that Garrett said, if there is actually one thing that is clearer than voting right, gun rights under the Privileges or Immunities Clause, it was stated by the Joint Committee on Reconstruction, which reported the 14th Amendment to Congress, that this amendment has nothing to do with voting rights. They explicitly said that. This doesn't confer the right to vote on anybody. So I think Garrett's view, you know, if you're looking at original meaning in any meaning, and there's a lot of contextual background to that as well. So if you're looking to original meaning, it doesn't have anything to do with political rights. You're going to have to get there through the 15th Amendment if you get there.
Well, it's curious that the framers then used the term the right to vote in Section 2 and imposed a penalty for abridging
right.
it. Maybe that doesn't mean anything. It means something to me.
Yes, it means exactly what it says. It says if anybody is not allowed to vote in those states, now that should be enforced. That the representation of those states should be reduced in Congress. But that's something very different. They took out a right to vote provision and they made an explicit decision to take out the right to vote provision. And with respect to felon disenfranchisement, they explicitly recognized that in Section 2. So I'm not.
Well, we can continue to go on there,
but my point is, if you're talking about original meaning, and original meaning It doesn't have anything to do with the right to vote. They said so.
And this is the future of the 14th Amendment right here. You're seeing it play out in real time.
Well, I can't help but say this demonstrates that originalism is not constraining, right? I mean, we're seeing out live how much originalists disagree amongst themselves and why it's difficult for it to be the theory that judges use to interpret. I really respect it as a theoretical exercise. I think there's a lot we gain, and I tell my students again, there's no judge on the court who should ever say that they're not interested in the specific intent of the framers or this kind of originalism as history, but as a cogent way of limiting the Constitution and interpreting it consistently, I think it's just a challenge, and it shows that any way you interpret the Constitution leaves a lot of discretion to whoever's doing the interpreting.
I mean, I know we're at the end. I've sat through a number of knocks on originalism quietly, but I think let me just say a few things on behalf of originalism. Nobody who is an originalist and who thinks that the original meaning ought to constrain where it's discoverable thinks that that means it just constrains or dictates the results in all cases. No originalist thinks that thing. There is a difference between figuring out the meaning of the Constitution is and then putting that meaning into effect. And to put that meaning into effect is going to require a lot of choice. It's going to require the development of implementing doctrines that are more or less true to that original meaning, the spirit, as opposed to the letter. And there's going to be a lot of room for disagreement about that. So the debate really isn't about where originalists may disagree, then that shows that originalism doesn't constrain. It's about what do you do when everyone does agree about what the original meaning of the text is. At that point, are judges authorized to override what is the consensus view of what the original meaning of the text is? That is the claim that's made by non-originalists in defense of the so-called living Constitution. In my view, the only living Constitution is one that's actually followed. And one that's ignored or can be superseded by judges or anyone else is actually a dead Constitution.
Okay, well, thank you to each of the panelists, and I wish we could continue the debate, but hopefully we will host many more conversations along these lines in the future and throughout the next year. So thank you so much for joining. Sorry. Great. Okay, we can go back to the green room that way, yes. I'll follow you.